We are on the record for the hearings and the matters listed in the North Dakota Industrial Commission hearing docket for June 5th. I am David Garner, hearing examiner for these hearings. We are at the hearing room for the Department of Mineral Resources, Oil and Gas Division, and it is 9 a.m. There's only one case on the docket. Before I get to it, I just want to note that there are several pending motions that the Commission will not decide before the hearing takes place. Objections can be made and preserved throughout the hearings, as far as those motions concerned. Therefore, I'll be allowing the evidence and testimony and the scope of the hearing without consideration of the motions, but at the time we issue the order, we will take into consideration the motions and give that evidence, testimony, and scope its due consideration. With that, I will read the case into the record. Application of Thurman Andrus, Melissa Sandifer, Julie Sandifer, Lisa Sandifer, Thomas Thompson, and Robert Bob Fulweiler, MCTAN Holdings LP, Tejon Exploration Inc., Rhonda K. Up, and David Halbert to consider the allocation of production attributable to them from the Carson Peak 4-35 HS well and Whitman FIU 13-34 HSL well, section line wells, based on their interest in the underlying spacing unit consisting of sections 23, 26, and 35, Township 147 North, Range 96 West, and sections 2, Township 146 North, Range 96 West, Dunn County, in the Oakdale Field. All interested parties, please come forward. And what we'll do here is, why don't we announce who's come forward first, and then we'll go back, and Mr. Swanson, you can begin.
Sure, thank you. Josh Swanson for the applicants. Vogel Law Firm. Sorry. Josh Swanson for the applicants, Vogel Law Firm out of Fargo. With me here this morning are several of my clients, including Thurman and Lily Andrus, Melissa Sandifer, and Sean McLaughlin from McTan Holdings, along with our expert witness, Dwayne Stewart.
Good morning. On behalf of Continental Resources, I'm Jen Kaiser with Continental Resources. I also have co-counsel David Bankston with Stinson LLP. Additionally, we have 3 witnesses today. TJ Boschelet, our land supervisor for the Williston Basin, Sarah Hale, our manager for reservoir development of the Williston Basin, Mark Okerman, our director of exploration, and also in attendance as corporate representatives, we have Mr. Harold Ham, our founder and executive chairman of Continental Resources, Robert Hagens, our senior VP of land for Continental Resources, and Denise Percival, our land manager for the Williston Basin.
Derek Broughton Law Firm, Bismarck, North Dakota, here on behalf of several mineral owner interveners, Shirley and Dean Meyer, Sheila Murphy, Rodney Richner, estate of Mike Golden and Mike Golden Incorporated, Grace Link Family LLC, and Jar Investments LLC. And I also have my paralegal Desiree Zast here with me.
Okay, with that, Mr. Swanson, you can proceed.
Thank you. And as a preliminary matter, before we get into the testimony, I've talked with Mr. Bankston, counsel for Continental, with respect to the Commission's reserving its ruling on the motions, rather than myself or opposing counsel making a bunch of objections. We've agreed to a standing objection, so what I anticipate is, for the record, we would make that once, but just so this record reflects that Andrew Sandifer, along with Continental, was agreed to standing objections based on the motions and briefing that's been filed.
That's fine.
Okay.
Your Honor, may I put an objection on the record before we get started as
Yes.
well? Thank you. On behalf of the intervening mineral owners, we object to the proceeding going forward in the hearing based on the lack of notice to the other mineral owners and the way that an allocation proceeding could impact not only the mineral owners that I represent, but hundreds, if not thousands, of mineral owners that are unrepresented right now without notice. And so for that reason, we would also ask to not have to argue this all day, but just ask for a standing objection to the proceeding based on our motion to continue in the lack of notice.
That's fine.
Thank you.
Likewise, Commissioner Garner, Continental would like to clarify its standing objection as well. as to everything in our motion to limit the scope of the hearing, to the extent Mr. Swanson is allowed to introduce new claims, new relief. We reserve our right to object to those at a later date and potentially submit new evidence as to that after the hearing. And we'd also like to take notice of the lack of jurisdiction over those other claims for relief, given the lack of proper notice in the notice of this hearing.
Okay, thank you.
With that in mind, I would also like to note, yesterday at 12:08 p.m., Andrew Sandifer was served with supplemental discovery responses. No documents were provided this morning at 8:24. When I walked into the hearing room, counsel for Continental handed me their exhibits. We too would reserve the right to put in a rebuttal report addressing their exhibits. We have not had time to review them as we were just provided with them this morning. So we do, in addition to our motion to exclude, want to be clear for the record that we do object to the admission and consideration of the supplemental responses that were provided yesterday early afternoon, as well as the exhibits.
Okay, your objection is noted.
Your Honor, may I make one more objection in response to that as well, please?
Sure.
I want to just reiterate that the mineral owners who did not receive notice of this proceeding have not had the ability to participate at all. And so it's tough for us to hear the applicant who started this proceeding in August of 2023 complaining about a lack of information, given that we weren't even provided notice that this was happening. And so I think there should be some sort of an estoppel made against the applicant, given also that the applicant is the one that has the burden here, and Continental is responding to what they put on, and we haven't seen that yet. So it's all rebuttal on Continental's behalf anyway. So with that objection, thank you. I just asked to have that as a standing objection as well.
Your objection is noted.
The applicants will call Dwayne Stewart.
Okay, DJ up here. I'm gonna call our expert first. I need Sarah. Mr. Stewart, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Thank you, and before proceeding and going through, what we'll offer is petitioners, or excuse me, applicants, Exhibit 1, which is Mr. Stewart's resume. I did talk to counsel with Continental. I don't know that they'll stipulate to the qualifications and foundation, but at this time, what I would like to do, rather than spending, unless the commission wants to spend 20, 30 minutes on hearing about his resume and background, I would just offer Exhibit number 1, which is Mr. Stewart's resume and CV, and ask that the commission qualify and hear his testimony as an expert witness.
On behalf of Continental, assuming that the statements made in his CV are true and correct, which I don't have any reason to doubt, we don't have any objection to his qualifications, but would reserve the right to introduce evidence on cross-examination or otherwise it goes to weight and credibility.
Okay. I'm going to admit the witness as an expert and allow Continental to question.
Okay, thank you. Mr. Stewart, Exhibit number 1, what is that?
My resume.
Did you prepare it?
I did.
Does it accurately reflect your education, work experience, and training with respect to the matters that you've been asked to testify to?
It does.
Andrew Sandifer would offer Exhibit number 1 into evidence.
Exhibit admitted.
Let's jump right into the meat and potatoes. Dwayne, are you familiar with the claims made by Andrew Sandifer to the commission in their application in this matter?
I am.
What is your understanding of those claims?
That they are seeking to receive an allocation of production from exceptional locations, or another term is lease line wells, located in the south half of the Oakdale field.
What were you asked to do in your capacity as an expert for Andrew Sandifer with respect to their application?
To prepare an interference report, or at least to investigate the possibility of interference of those lease line wells in the south half of Oakdale field. And if I determined that there was interference, to quantify said interference.
In performing that analysis and reaching an opinion and coming to conclusions, did you indeed prepare a report?
I did.
Can direct your attention to applicant's exhibit number 2. What is exhibit number 2?
Exhibit number 2 is the actual interference report that I performed on the section line wells in the south half of Oakdale field.
And what exactly was the purpose, and what were you looking to determine with respect to that report?
The point of the report, or the purpose of the report, was to look at those section line wells located along the center axis in the south half of the field to see if they're having any impact, either positive or negative or neutral, on any of the surrounding wells around those lease line wells. And if there was, then to quantify it.
On the cover, the front page of exhibit number 2, is that your signature?
Yes,
Did you prepare this report?
I did.
Did anyone else assist you in preparing the report?
No, other than any documents that I may have pulled from public domain or from the clients themselves.
This time I offer applicant's exhibit number 2, Mr. Stewart's section line well interference analysis report, for evidence in this matter.
Any objection?
I do have some objections, Mr. Hearing Examiner, other than the standing objections, which should be noted for the record. I also have an objection to, at page 3 of this report, in the third paragraph, you'll see that Mr. Stewart refers to alleged injuries to correlative rights. There's one, that they forfeited production and revenue due to precautionary shut-ins for lease line operations. 2, confiscation of hydrocarbons due to interference. 3, increased lease operating expenses for water disposal that originates from lease line fracking operations. And 4, increased workover expenses as a result of sand cleanup, pump changes, and a result of lease line fracking operations. We believe that all of those alleged claims and opinions relating to those claims are beyond the scope of the application, but also they're beyond the scope of what the commission has jurisdiction to decide. They appear to be claims for damages, money damages, injuries, and of course the commission does not have jurisdiction to decide those types of issues. So to the extent his opinions and his report include any statements concerning those alleged tort claims, damages, injuries of that sort, we would object.
And if I may, for the
Your Honor.
record, Andrew Sandifer has addressed that in detail in their response to Continental's motion to limit scope, and explained why those all speak to the claims related to correlative rights and interference made in their application. And to be clear, nowhere in the application is Andrew Sandifer asking the commission to award money damages.
Your Honor, I just want to remind the parties in the commission that we are parties here now, and we should have a right to respond to these motions and objections as well. And I wanted to lodge an objection previously to the resume and the qualification of this witness as an expert. I understand he probably is an expert, but the questions that follow and whether there's foundations for questions asked is a different question, and whether his testimony that comes next is within his expertise is still an open question, so I object to any testimony that goes beyond that expertise. I also object to the report itself coming in, specifically because it's hearsay, but also because we have a live witness here who can testify and lay the foundation and provide the support for that with live testimony, and so I don't think the report should come in for that reason either. So with that objection, thank you for the opportunity. I appreciate it.
Okay, I apologize for not giving you an opportunity to object. to the expert status. I will note your objection, but I'm going to continue with my ruling on that. Once again, I will note the objections of counsel, in this case, to this exhibit, but I'm going to admit the exhibit.
Thank you. And just so I'm clear, my understanding is that the commission has already ruled and received Mr. Stewart as an expert and qualified him as such. Is that correct?
That's correct.
Okay, thank you. In your nearly 30 years of experience in the oil and gas industry, going back to 1995, Dwayne, how many occasions have you had to work on projects similar to Exhibit 2, where you have looked at how certain oil and gas wells impact or interfere with other oil and gas wells in a certain area?
As it relates to interference, I don't have the exact number, but I would tell you it's well over 1,000 different cases, 1,000 different times. I mean, reservoir engineers consistently and holistically look at interference because we're always trying to determine the difference between capture versus acceleration. So you want to understand the interference that you have when you're drilling multiple wells into a common source of supply.
And so the record's clear, when you say interference, what exactly do you mean by that?
So interference from a petroleum engineering standpoint is just simply when a well, either production from a well or injection into a well, causes either a pressure change or a fluid change in an offset well. So that's a very good layman's definition of what interference is.
Are you a petroleum engineer?
I'm a licensed petroleum engineer,
Are you a member of any organizations related to petroleum engineering?
SPE,
What is SBE?
Society of Petroleum Engineers.
Okay. When you did your review and analysis that's reflected in your report, did you answer those questions and come to any conclusions and opinions as to whether the Carson Peak 4 and Whitman FIU 13 section line wells impacted and interfered with the wells in the underlying spacing unit that the Andrus Sandifer Group have an interest in?
I did.
I have one objection, just clarification. When Mr. Swanson uses the term underlying spacing unit in this hearing, that's been defined by him in his pleadings. I'd just like to know how he's using that term.
I think it speaks for itself because it is very well defined in the pleadings, and in fact, in Continental's pre-hearing brief and in their previous motion to dismiss, it was very clear that they understood what the underlying spacing unit was.
The Morris Carson Peak unit?
Dwayne, well,
I'm going to overrule the objection.
Dwayne, in your report, did you prepare any figures or visuals that reflect where the overlying and underlying spacing units are located in the Oakdale field?
I did.
Can you direct the commission's attention to where that is at in your report?
If you would turn to page 7 of 40 of the report, which is the Andrus Bates number 8, to figure 3.
Okay. So if I look at it, Dwayne, figure 3, I think you said it was on page 8. It looks to me like figure 3 is on page 7, stamped Andrus 8. Is that correct?
That's what I thought that's what I said, but I could be mistaken.
Okay. And what does figure 3 show with respect to the underlying spacing unit and overlying spacing unit?
So figure 3 is a picture of the Oakdale field. Oakdale only covers 8 sections. In the east half of Oakdale, which is sections 23, 26, 35, and 2, there is an underlying or base spacing unit. It's a stand-up 2560. In the west half of Oakdale, there's also a stand-up 2560, which covers sections 22, 27, 34, and 3. So that's the east half is the blue vertical stripes, the west half is the red horizontal stripes. The solid black outline is the boundaries of Oakdale Field proper. And then if you notice overlaid on top of sections 34, or at the boundary, perimeter of 34, 35, 2, and 3, there's a dashed red outline. That is the overlapping spacing unit that covers the south half of Oakdale Field.
With respect to figure 4 on page 8 of 40, what does figure 4 show?
Figure 4 is a repeat of Figure 3 with the inclusion of the 2 section line wells where they're showing the stick diagrams of where they're located.
I'll go back to my question prior to the objection, because I don't know that it was answered. With respect to the interference and impact issues and the impact on Andrew Sandifer's correlative rights, did you come to any conclusions or opinions as to whether the Carson Peak 4 and Whitman FIU 13 section line wells impacted, interfered with the wells and the underlying spacing unit that the Andrew Sandifer group has an interest in?
My same request, I didn't object to the question. I asked for a clarification of the question of what he meant by underlying spacing unit. And that request for clarification still stands.
And my understanding was the objection was overruled.
Yes.
With all due respect, it wasn't an objection. It was a vague and ambiguous question.
And I believe he clarified, correct me if I'm wrong, that the underlying spacing has been defined in the briefs and.
In the briefing, it's the very heart of this matter. It's certainly not in dispute, and I think everyone understands very well what the underlying spacing unit is. And Mr. Stewart has also testified what it is based on figures 3 and 4 in his report.
I disagree. It's defined to me, if it's defined in the caption of this case, if it's defined in the application of this case, I think it's clear what it is. If it goes beyond that, then I believe it's not clear.
May I add, Your Honor, an objection? I join in that because the other problem we have here is we're using as if they're terms of art that have been defined by the applicant himself. And what we're talking about here are different spacing units with different pooling orders that apply to different people. And it is important which units we're talking about and how they interact. And so I join in the request for clarification, just to be clear on the record, that dealing with units outside of the pooling order and the wells under issue and in dispute is problematic if it's not part of that caption and case request. So I join in that request.
I am going to let the witness proceed. I believe the clarification has been offered. I'm sorry, did you have some?
Now, I guess I heard Mr. Swanson's explanation, and I don't believe it clarified it for me. He still hasn't defined it specifically.
I believe he just answered that, and I believe it's very well defined in the case file in this matter.
Correct.
Mr. Stewart, can you go ahead and answer my question, or do you need me to re-ask it?
Please re-ask.
Okay. With respect to the interference and impact issues as to Andrew Sandifer's correlative rights in the underlying spacing unit, did you reach any conclusions and opinions as to whether the Carson Peak 4 and Whitman FIU 13 section line wells had any impact or interference on their interest in the underlying spacing unit?
I did.
Well, what were those?
As far as the quantity, the quantum, or the actual impact itself?
Well, let's start with the actual impact. Did the 2 section line wells here, what you refer to as CP4, the Carson Peak 4 well and the Whitman FIU 13, did they have an impact and interfere with Andrew Sandifer's interest in the wells in the underlying unit?
They did.
Okay. How did you determine that?
So when you look for interference, just a standard course of business, you need to establish basically what performance was for a base or legacy or parent well before an infill well is drilled. Another term for an infill well is a child well. So if you can establish a pre-interference decline curve, then you look subsequent to that infill well being developed, you look to see is there any change in performance in the parent well. And if the answer is no, then there's no interference. But if there is a change between pre versus post infill drilling, then you have a very, very strong correlation that there has been indeed interference.
Okay. Is there any figure or table in your report that quantifies that?
Yes.
Where is that in your report where that's quantified?
I'm going to pull a page out of my document. But if you are able to look at Andrus Bates number 19 and 20 side by side, which represent figures 12, 13, 14, and 15, figures 12 and 13 are post-interference, figures 14 and 15 are pre-interference for the Carson Peak 2.
And is there a table or anywhere in your report where you actually quantify and put numbers to that interference?
I do. For the Carson Peak 2, it's Table 2.
Okay, and what does Table 2 show? Well, it's Table 2, that's on page 2040, Andrus document, Bates stamp 21. What does Table 2 show?
Table 2 is literally just a table quantifying the impact of both oil and gas, a change, a pre versus post forecast of EUR, which is estimated ultimate recovery, out of the Carson Peak 2 well. Basically, you're looking at it before and after the Carson Peak 4 well was drilled.
Okay. And what were those impacts after the Carson Peak 4 section line well was drilled?
So the total lost production in the Carson Peak 2 will total just over 342,000 barrels of oil and just under 336 million standard cubic feet of gas.
And that's due to interference caused by the Carson Peak 4 section line well?
It's due to interference.
Due to interference from what?
Preponderantly, the Carson Peak 4 well. Almost 90 to 100% of it is due to the Carson Peak 4 well.
Is the Carson Peak 2 well that's so impacted located in the underlying spacing unit where Andrus Sandifer's interests are located?
It's spaced in the stand-up 2560, if that's what you're asking, yes.
Okay. You can turn to page 23 of 40. It's stamped Andrus 24. Let's start just generally speaking, Dwayne, these tables on page 23 of 40. What are you looking at and examining here?
So Table 3 and Table 4 are a repeat of Table 2, but I'm looking at different wells. So whereas Table 2 was a pre and post interference for the Carson Peak 2 well, Table 3 is a pre and post interference for the Whitman 2 well, and Table 4 is a pre and post interference analysis for the Whitman 3 well.
Are both the Whitman 2 and the Whitman 3 wells that are examined in tables 3 and 4, are those wells also both located in the underlying spacing unit where Andrus Sandifer's interests are located?
They're located in a stand-up 2560, but not in the east half of Oakdale Field. These two wells are in the stand-up 2560 located in the west half of Oakdale Field.
And Andrus Sandifer has an interest in both those wells, is that correct?
Objection assumes facts, not in evidence.
Overruled.
Yes, they do.
And with respect to the interference, let's start with Table 3. What did you determine with respect to whether there was interference by the drilling of a section line well? That's at issue here. Actually, let me back up, Dwayne. The interference in table number 3, what section line well is that related to?
It's the Whitman 2 well, which is Table 3, actually sees interference not just from the Carson Peak 4 well. It actually sees interference from both the Carson Peak 4 and the Whitman FIU 13, which is interesting because the Whitman FIU 13 was landed in the deeper Three Forks 1. And so what the Whitman 2 well shows here is that interference doesn't just stay in zone. So if you land a well in Middle Bakken, you don't just look at the Middle Bakken, you'll actually see interference from Three Forks 1, so it crosses benches.
So the interference when you arrived at what you call the delta, the difference, pre and post drilling of those two section line wells, what did you do and what did you look at to come to those numbers that are noted in Table 3?
So Table 3 is built upon figures 16, 17, 18, and 19. Once again, pre and post interference. And there are call-outs listed for those 4 figures. And so what these call-outs are designed to do is to draw the reader's attention to points that the Whitman 2 were shut in at various times for offset drilling and fracking operations, and also point out step changes in water-oil ratio once you brought the well back online. So if there was no interference, you would not expect to see a step change in water-oil ratio. It also points out changes to gas-oil ratio and performance of gas-oil ratio, and it also points out changes, steepening or step changes down in the oil production. So absent interference, you wouldn't expect to see any of those behaviors or telltales that would accompany a well when you bring it back from shut-in. In fact, actually, you'd expect it to perform better because generally when you shut in a well, you get what's known as flush production post-shut-in. That's not what's happening here.
Okay, well, what is happening here?
Just the opposite. You're seeing a steepening of decline, you're seeing a ramping up of GORs, you're seeing a step change in water-oil ratios, and you're seeing a drop in estimated ultimate recovery in a pre versus post-decline curve analysis.
So when you say there are telltale signs of interference, both in your testimony and your report with respect to the Carson Peak 4 and Whitman FIU 13 wells, the interference they're creating to the wells that Andrew Sandifer have an interest in, those telltale signs, is that what you were just referring to?
Some objection assumes facts not in evidence as to Andrew Sandifer's interest in the Hawkins and Whitman unit.
Can I address that issue?
Well, hang on. There's, and I would at this time offer exhibits 4, 5, and 6 for the record that are in the binder. Continental stipulated to Andrew Sandifer having an interest in the underlying unit. Their interests are identified in the briefing, so I think those facts are in evidence.
I just want to point out that the applicant hasn't provided me with any exhibits or a binder or anything, and so I don't know what he is talking about right now.
Yeah, and the interveners just filed their motion to intervene on Monday morning, so I apologize, Derek, but we had our binders printed and weren't planning on the interveners being here, so it's not a slight, it's just,
No, I didn't mean it was.
yeah.
If I may respond, because he said something about what Continental had stipulated to. Yes, we did stipulate that the applicants had interests in the Morris Carson Peak underlying spacing unit, as that underlying spacing unit has been defined by the applicants themselves consistently throughout these proceedings. And that underlying spacing unit is sections 23, 26, 35, and 2. Which is on, if you look at figure 3 in his report, that's the blue hatched area. We have never stipulated, and actually, that they have an interest in sections 22, 27, 34, and 3. They've never asked us to stipulate to that because it's never been an issue in this application.
Okay, it's consistent with the standing objection,
Correct.
and so I'm going to allow the testimony, and we'll take it under consideration.
Thank you.
I don't know that you answered that question before the objection, Dwayne. But the interference, well, actually you did. You said that everything you testified to with respects to figures 16, 17, 18, and 19 related to tables 2, 3, and 4. Your testimony that you just said, those would be the telltale signs of interference on the wells Andrew Sandifer has an interest in, is that correct?
I did. And so for table 3, you look at those 4 figures before. Table 4, the 4 figures that go with table 4 are figures 20, 21, 22, and 23. That's basically pre and post interference for the Whitman 3 well. And then, did you ask me about table 5, or is that your next question?
Well, yeah, we'll get to
Okay.
table 5 in a minute here. And I'll note for the record at paragraph number 1 in the application, it does identify, and I quote, Andrew Sandifer owned minerals located in Dunk County, specifically sections 22, 23, 26, and 27, Township 147 North, Range 96 West. Dwayne, let's jump real quick before we get to table 5. What is figure 5, and what does figure 5 show in your report? On page 9 of 40.
Figure 5 is an exhibit previously submitted by Continental to this commission in case number 26144, showing and listing all the working interest owners in the stand-up 2560 located in the east half of the Oakdale field.
Okay. And that would include the applicants in this case, correct?
Correct. In fact, actually, this is a true and correct copy of that exhibit, except for the red boxing around the 10 working interest owners or lessees, and then the subtotaling of those 10 lessees was added by me in the preparation of this report.
Table number 4, what is the significance, what's shown in table number 4 on page 23 of 40?
Table 4 is a repeat of tables 2 and 3, but instead of looking at either the Carson Peak 2 or the Whitman 2, table 4 focuses on the Whitman 3.
Okay, and what did you look at to determine that there was, well, let me back up. What does table 4 show with respect to interference on Andrew Sandifer's interest?
So what's going to happen here is the gross 8/8 volume of oil that's going to be reduced due to interference in the Whitman 3 is a little over 200,000 barrels of oil and almost 400 million standard cubic feet of gas.
The data and analysis that you looked at table 4, similar question that I asked you about table 3, what did you look at in coming to those conclusions? What figures would the commission have to look at?
For table 4, you need to look at figures 20, 21, 22, and 23.
So figures 20, 21, 22, and 23 on page 24 and 25 of your report. What is the significance of those figures? What do they show with respect to the interference and impact on Andrew Sandifer's interest?
It's the same situation that we're seeing in the Carson Peak 2 and the Whitman 2, is that subsequent to lease line wells being developed, we're seeing step changes in water oil ratio, we're seeing slope changes or inflection points in the crude oil production trend, we're seeing ramping ups of GORs. So the same telltales that were present in the prior 2 wells are also present in the Whitman 3.
When you say GOR, what does that abbreviation stand for?
Gas oil ratio. In this case, the metrics or the units for gas oil ratio are standard cubic feet per stock tank barrel.
Okay. And what is the significance of that delta in table 4 with respect to Andrew Sandifer's interest in the Whitman 3 well?
I'm sorry, can you repeat the question?
What is the significance of table 4 with respect to what it shows as far as Andrew Sandifer's interest and the impact the 2 section line wells had on those interests?
Yeah. Basically, in short, the lease line wells that are being drilled, in this case, the Carson Peak 4 and the Whitman FIU, they're materially reducing the through wellbore reserve. So basically, wells that Andrew Sandifer do not have a working interest in are materially reducing the through wellbore reserves of wells that Andrew Sandifer do have a working interest in. So it's you're taking from what they have, and it's being produced from wells that they have nothing in.
With the produced through wellbore reserves, can you just explain to me, and I think you already did, but explain to me what you mean by that with respect to Andrew Sandifer's interest?
So a through wellbore reserve is the physical oil and gas, barrels of oil and standard cubic feet of gas that physically come out of that wellbore. So if you have a unique NDIC number or an API number, that's the quantum of oil and gas that comes out of that wellbore.
With respect to table number 5 on page 23 of 40, what's being shown in table number 5? What's the significance of that?
So table 5 takes the bottom row of tables 2, 3, and 4 and sums it up. So this is the overall net impact. If there were positives or negatives, then they would start to cancel out here. But in this case, table 2, table 3, table 4 is a loss, and a loss. And so when you go to table 5, the combined loss sums up to just over 900,000 barrels of oil and just over a BCF, or a BCF of natural gas.
In other words, the three wells that Andrew Sandifer have an interest in that you examined, the CP2, W2, and W3, is it fair to say, or is it correct to say that under your analysis, they lost approximately 912 million barrels of oil and 1,037 million MCF of gas due to interference caused by the two section line wells?
I'm going to correct, you said 912 million barrels, I think is what you said. The M stands for 1,000, so it's 912,000 standard barrels. And let me point out for the record, that's not Anders Sandifer's loss. That's the gross 8/8 portion. Anders Sandifer has a working interest, so it'd be a fraction of this number. It'd be a proportionate of this number is what they actually lost.
So that number would reflect all the owners in the base unit, the underlying spacing unit.
This is how much oil and gas all owners in these three wells lost in gross 8/8 total.
Because of interference from the Carson Peak 4 and Whitman FIU 13 section line wells?
Correct.
The figures and data that you looked at to arrive at those numbers, how did you get to those two numbers? What did you look at with respect to Table 5 to arrive at those? Are they the same figures you talked about this morning?
Yeah, Table 5 doesn't have figures that go with it. Table 5 is the summation of Tables 2, 3, and 4.
And the figures that are related to Tables 2, 3, and 4 would be the ones that you relied on in coming to the math in Table 5?
Correct. That's figures 12 through 23 inclusive.
You can jump back to page 3 of 4 for me. 340? Excuse me, 340, thank you. It's stamped Andrus 4. One of the things you note is that there was confiscation of hydrocarbons due to interference. Would that confiscation be reflected in those numbers in table number 5 then?
That's exactly right.
Okay. Would that forfeited production and any related revenue also be reflected in that table 5 then? A
No.
product of that? Okay, when you say on page 3 of 40, Andrus 4, that Andrus Sandifer forfeited production, et cetera, how did you make that determination?
So if you look at figures 12 through 23, and the best figures are basically figure 12, 16, and 20, which is what petroleum evaluation engineers refer to as a log rate versus time plot. You can see that the points coming along by month drop to 0 in those graphs versus time. And so those 0 points are essentially shut-in periods that the Carson Peak 2 or the Whitman 2 or the Whitman 3 wells are shut in due to offset operations. So the drilling and or fracking of an offset well.
When you talk about that in your summary, the increased LOE, lease operating expense for water disposal, water disposal that originates from lease line fracking operations, are those water, the evidence of that water, is that reflected anywhere in your figures that you examined?
It is.
Can you point out to the commission where that's reflected?
Yeah. So the purple or violet color that's variable that's listed, WOR, stands for water oil ratio. You can see in the various plots over time between figures 12 and 13 where in every single situation post shut-in, the water oil ratio plot jumps. For example, in figure 18, the water oil ratio in mid-year 2022 or the first quarter 2022 for the Whitman 2 is running right about 0.2, so that's 0.2 barrels of water per barrel of oil. Mid-year 2022, this is right after the Whitman FIU comes online, the water oil ratio jumps up to above 2. So there was a 10-fold increase in water oil ratio and the well was only shut in. That water didn't magically appear out of nowhere. It came from somewhere, and the most likely explanation is from the exceptional location that was perfed and fracked right offsetting it.
So based on your review and the figures in your report, is it correct to say that the WOR, the water oil ratio, increased due to the drilling of this Carson Peak 4 and Whitman FIU 13 section line wells?
It's not due to the drilling, it's due to the completion.
Excuse me, completion, yeah.
Right. And might I add, notice the water oil ratio trend in figure 18 is declining over time. So they're producing out that excess water. So another term we use is it's drying out. And so that's, once again, if this was an encroaching water oil contact, you wouldn't have a falling water oil ratio, you'd have a climbing water oil ratio. So this is new water that's been introduced to the reservoir due to completion operations.
Yeah, on page 4 of 40 in your summary, when you concluded there's increased WOE workover expenses as a result of sand cleanouts and pump changeout as a result.
Base 4.
Yeah,
You said page 4.
excuse me, I meant, yeah, Bates 4, page 3 of 40. Thank you.
What was that base number again?
Bates number 00004. It's page 3 of 40 in the
Got
report.
it, sorry.
Yeah. So when you write in there and conclude in the third paragraph, there were increased WOE workover expenses as a result of sand cleanouts and pump changeouts as a result of lease line fracking operations. How did you determine that and come to that conclusion?
So the LOE is easy, because lease operating expenses are the best predictor for LOE is water production. It correlates best. So your lease operating expenses correlates best to water, which is very true because water is the heaviest product that we lift. So all your artificial lift is designed to get the water out of the wellbore. So there's a reason why LOE correlates best to water. So the LOE is very straightforward. If you increase your water oil ratio from 0.2 to 2 or a 10x increase, your LOE is going to increase, step change. The workover rate, the workover expenses, when you have fracture-driven interactions or FDIs in offset operations, then what happens is you can bring fluid and or proppant into the parent well. Depending upon how severe that proppant is in the parent well, then you will often see workover operations going in either with coil tubing unit or stick pipe to physically sweep and clean the sand out of the parent well. I will tell you, having pulled many pumps myself, you get any sand in a rod pump, it's going to lock it up. And so now you're having to replace pumps, or if you're running ESPs, you're going to have to replace ESPs. And so those issues all happen from time to time in offset wells.
So is it correct to say then there's a relationship between the two section line wells, the Carson Peak 4 and Whitman FIU 13, and increased workover expenses as related to the wells Andrew Sandifer has an interest in?
Yes.
On page stamped 27, it's Andrus 27, page 26 of 40. You talk about using a multivariable regression analysis performed on LOE for Oakdale. What exactly do you mean by that?
Where are you?
It's page 26 of 40, Andrus 27.
What paragraph?
It's the very top paragraph. In addition, it starts page 26 of 40.
Got it.
In addition to correlative rights infringement caused by hydrocarbons produced via lease line wells with zero Andrews Sandifer working interest, a multivariable regression analysis was performed.
Right.
So when you say a multivariable regression analysis was performed, what are you talking about?
So multivariable regression is a fancy way of saying a statistical technique was used to attempt to correlate a dependent variable, in this case LOE, against multiple independent variables, in this case oil, gas, and water production. So engineers like to use big words, and that's one of them.
So do lawyers. The figures on that, are those the figures you've already talked about in this morning that are reflective of that?
The LO,
I don't know what you're talking about. Figures reflective of that.
The figures, the multivariable regression analysis, Dwayne, in your report, where would we look at to see where that is?
you're not going to see it in the report per se. The reason why the LOE is just an input that goes into the economic model that you're seeing the output of in figures 12 through 23. So you've got lease operating expenses you've got workover expenses, you've got prices, differentials, shrinkage, all those components of an economic model are baked into figures 12 through 23.
Okay. And what is the relationship between the LOE and WOE analysis that you did and Andrew Sandifer's correlative rights as to the wells in the underlying unit?
So, can you rephrase the question? I'm not sure.
Yeah,
I follow.
what is, I'm asking what's the significant, in sum, what's the significance as far as Andrew Sandifer's
Right.
interest in the underlying unit? What's the significance of the LOE and WOE that you discuss in your report and that you've testified to here?
I did not quantify the incremental LOE. I'm not sure if this is what you're asking, but I did not quantify a dollar amount of incremental LOE or WOE. It simply stated that this is a penalty that they incur for this type of interference. So I'm not certain if that answers your question, but I didn't quantify that because I felt like that was a little bit beyond the scope of trying to put a dollar amount of how much incremental harm or injury they've been done. I was just asked to quantify the barrels in cubic feet of gas.
Gotcha. When the Carson Peak 4 and Whitman FIU 13 wells were drilled, do you know were any of Andrew Sandifer's wells in the underlying unit shut in?
Yes.
Which ones? Can you give me an example?
So if we go back to figure 12,
Let's hang on. Let us turn to figure 12 here. Figure 12 on page 18 of 40, Andrus 19.
correct? So the CP2, the Carson Peak 2 well, which is spaced in the stand-up 2560 on the east half of Oakdale Field, was shut in late 2018 for infill drilling. It was returned to production, or RTP'd, in November of 2019. So you had about a 13-month period that well was shut in for offset operations. If you look at that, then you can see that the water-oil ratio in this well jumped. There was a precipitous material decline in oil production, and the GOR ramped up immediately subsequent to being brought back online.
Were there same impacts to other wells in the underlying unit that Andrew Sandifer have an interest in?
If you go from this well is east of the Carson Peak 4, you would have to go west to the closest offset, which you'd be looking at the Whitman 2 and then also the Whitman 3.
When after the CP4, the Carson Peak 4 and Whitman FIU 13 wells came online, what happened to the production from the wells like those in figures 2, 3, and 4 that Andrew Sandifer have an interest in after the CP4 and Whitman FIU 13 came online?
So generally speaking, you'll see rising or ramping GORs, you'll see step changes in water oil ratios, you'll see decline in oil production. It's consistent telltales across the board. Anytime these infill wells are drilled, you'll see an interference pattern in offset in proximal wells.
Table number 6 on page 27 of 40, which is Andrus 28. What is table 6?
So table 6 is basically just trying to highlight and show the telltale impacts of drilling infill wells, and in this case, we're looking at the two exceptional locations, or basically lease line wells, that are situated between the Whitman 2 parent well to the west and the Carson Peak 2 parent well situated to the east. And so it helps when you look at table 6, if you look at figure 10, you can see this table is arranged with the Whitman 2's the most west, then the Whitman 13, FIU 13, Carson Peak 4, and Carson Peak 2. So this table is arranged spatially the same way you would find them in the reservoir if you were looking from the south end of the field.
And what is the significance as far as what table 6 shows in relation to the impact on Andrew Sandifer's interest in the underlying spacing unit?
So what you see is that parent wells that were drilled early had large or high hyperbolic exponents, which is the B factor of 1 or greater than 1, you had basically long periods of time of flat gas-oil ratios, 6-7 years. You see low water-oil ratios of 0.02. We're talking about very small water-oil ratios of 0.02 to 0.05. And when you contrast that to the section line wells or the lease line wells that were drilled, what we start seeing is a ramping in gas-oil ratio. And in fact, if you look at the Carson Peak 4, which it was turned in line in June of 2019, so 8 years after either the Carson Peak 2 or the Whitman 2, it ramped, its gas-oil ratio went from 1,000 to over 3,000 in only 2.5 years. Whereas the two parent wells sat flat at 1,000 standard cubic feet per stock tank barrel for 6-7 plus years. When you compare that to the Whitman FIU 13, which just recently came online in July of 2022, it went from 1,000 to over 3,000 in less than 12 months. So what we're seeing here is that by infilling, drilling these lease line wells, they're exacerbating the interference and the production characteristics of the parent wells.
So to sum it up, is it fair to say, based on your review and analysis, that this Carson Peak 4 and Whitman FIU 13 section line wells had a negative impact on Andrew Sandifer's interest in the wells in the underlying unit?
Yes.
In your reported exhibit number 2, you reference a reserve report. Is that reserve report exhibit number 3, which starts at Andrus 45 and goes to Andrus 498?
Yes.
And what is the relationship of the reserve reported exhibit 3 to exhibit number 2?
So all the economic modeling that was done for the reserve report was repurposed and reused for the interference report. So all the base assumptions, whether it be LOE, workover expenses, prices, differentials, shrinkage, everything that was done in the reserve report earlier this year was basically reused in preparing this interference report.
So fair to say that, I mean, I think you stated in your report, but did you rely on and incorporate your findings in Exhibit 3, the reserve report, into the work you did with respect to Exhibit 2?
Yes, all the figures 12 through 23, essentially pre and post interference, would have basically originated from this reserve report.
Did you prepare this reserve report?
Yes.
Did anyone assist you in preparing the reserve report?
No.
I'll offer petitioners, applicants Exhibit number 3, the reserve report, into evidence.
Any objections?
Subject to the standing objections already made.
Noted.
Same.
Noted. The exhibit will be admitted.
And while I got the witness here, just real quick, my understanding is that Exhibits 1, 2, and 3 have all been accepted into evidence. Is that correct?
That's correct, subject to the standing objection, correct?
Okay.
Correct.
Correct.
Okay. And subject to the same objection with respect to Andrew Sandifer's interest that council has objected to and I've responded to, I'd also offer at this time Exhibits 4, 5, and 6 into evidence.
Give me a chance, take a look at it.
Yeah, Exhibit 4 is an email from Continental's counsel to me dated December 11th, 2023. It's been filed with the commission previously. It is in the case file already. It's an email from their counsel stipulating to Andrew Sandifer having an interest. Exhibit 5 is a declaration that I prepared that includes the declarations at Exhibit number 6. The declarations at Exhibit number 6 were also already filed with the commission, and that's my clients, attesting to or stating the interest that they have here that are at issue. And that too was stipulated to previously by Continental as indicated in Exhibit 4.
Yeah, and as stated before, we have previously stipulated that the applicants do have an interest in the underlying spacing unit, which is defined as the Morris Carson Peak unit only. Our stipulations do not go beyond that and have not gone beyond that and don't go beyond that today.
And those objections have already been noted.
Or to, then again, I would ask that exhibits 4, 5, and 6 be, I'll offer them in the evidence in this matter.
Anything
No
further?
objections, other than standing.
Just standing objections, and also I don't know what they are and don't have them.
The exhibits will be admitted.
Right now, Mr. Stewart, those are all the questions I have for you. Thank you.
Why don't we take a 10-minute break right now? We'll go off the record.
Okay.
Okay, we are back on the record. I will note that the case file for this matter is on the first page of the website, which includes the exhibit. So anyone who does not have an exhibit and wants to access one. Attorney Broughton, I was just saying that the case file for this matter is on the first page of our website. And so anyone who wants to access the case file, including this exhibit, can do so by.
I do have the case file. Are all the exhibits in the binder filed in the case file?
They should be, so both reports.
I'm sorry, I have like the report 49 and then some exhibits, but is there,
Everything's in the case file. Everything's been previously provided before today with the commission.
but not as marked in the binders
No,
today?
they'll be stamped. What was marked in the binders, so what was marked, the Andrus 1 through 498, which is the interference report, the reserve report, and Mr. Stewart's resume, exhibits 1 through 3. They will also be stamped Andrus 1 through 498, just like these copies are.
Okay, thank you very much. I appreciate it.
Attorney Bankston, you can proceed.
Thank you. Mr. Stewart, good morning.
Good morning.
Mr. Stewart, is it fair to say that if you're not seeing interference between your wells, that you're not fully developing or draining all the reserves in your spacing unit?
That's probably a fair statement.
Okay. In your testimony today and in your report, you use the term and have referred to the base spacing unit. Is that correct?
That is correct.
Okay. And how do you define that term in the context of your report?
The base spacing unit reflects the spacing unit that the NDIC has prepared for prescribed, or said differently, interior locations. So in this case,
You lost me there.
the administrative code 43020318 talks about units designed for drilling of locations. Okay, that's where you go to in the administrative code, and so those drilling locations are defined. A unit is prepared. So in this case, you've got a stand-up 2560 that's been authorized pursuant to Section 18. The exceptional locations, which is what we're talking about right here, you look at 18.1. It's a subset underneath Section 18 in the Administrative Code. And the word exceptional location is in the Administrative Code, and the word prescribed location is in the Administrative Code.
These lease line or section line wells, are they exceptional locations?
Absolutely.
They're not permitted locations within the overlapping spacing unit, are they?
They are an exceptional location, and what happens is when an exceptional location is permitted, they create a unit around that exceptional location, and that hence the reason the term of art of used overlapping.
Okay. You're aware, are you not, that the commission has recently defined the term base spacing unit in the Petra Hunt case, which was case number 29902 and order number 33453?
I am?
Okay. And in that order, the commission defined base spacing unit as a base spacing unit is defined as the first spacing unit established for horizontal well development of the spaced lands. Typically a 320 acre, 640 acre, or 1280 acre unit in nominal size.
I am?
Okay. In the Oakdale field, the base spacing units, which were the first spacing units created in that field, were the Carson Peak spacing unit, correct?
Correct?
One of them. And the Whitman base spacing unit, correct?
Correct?
And also the Hawkinson base spacing unit, correct?
Correct?
And the Morris base spacing unit, correct?
Correct.
And all of those base spacing units were stand-up 1280 spacing units spaced back in 2006, roughly.
I think a little bit later than that, but
Okay.
I won't
But
argue the point.
you'll agree that those four base spacing units were the first spacing units established for horizontal well development in the Oakdale field, correct?
I will take exception to where you're leading this.
Well, is the answer yes or no?
The answer is not applicable.
That's not one possible answer. Is the answer yes or no?
The answer is not applicable.
So you won't answer the question.
Well, hang on, Dwayne, just, if you understand his question, just go ahead and answer it.
The answer, would you repeat the question?
Yeah, the question I asked you was whether or not the stand-up 1280 base spacing units in the Oakdale field for the Whitman, the Carson Peak, the Morris, and the Hawkinson were the first spacing units created for horizontal well development in the Oakdale field.
Yes.
And to this day, have any of those base spacing units been terminated?
They've been modified.
Have they been terminated?
Not officially.
Have they been terminated unofficially?
Yes.
Okay. Not by a commission order.
The two 1280s
that-
hang on, the two 1280s that you referred to were contributed to the stand-up 2560s.
Are you aware of any commission order terminating those base spacing units?
I am not.
And those spacing units remain in effect to this day, correct?
Yes.
Now, so when you refer to base spacing unit in your report as the stand-up 2560, the Morris Carson Peak unit, you're not using that term as it's been defined by the commission, correct?
Object. Object to form. You can go ahead and answer if you understand, Dwayne.
Repeat the question.
I said, when you refer to the base spacing unit in your report as the stand-up 2560 Morris Carson Peak unit, you're not using the term base spacing unit as that term has been defined by the commission, correct?
And I'll just object to the extent it calls for him to provide a legal conclusion or legal answer.
Overruled.
I believe I am.
How?
If I can draw your attention to figure 8.
What page is that on?
Page 13 of 40, which is Andrus Bates 14. Or I guess I should say Bates Andrus 14. What this figure shows is essentially a stick diagram zoomed in on 5 Carson Peak long lateral wells that physically have perfs on the Morris track. And so because Continental has physically put perfs on Carson Peak perfs on the Morris track, they're now literally perfing into what you're referring to as two 1280s.
But those wells are in the stand-up 2560, correct?
Exactly. They are in the stand-up 2560. So what happens is when you put perfs across into those two portions, Carson Peak and Morris, the stand-up 1280s lost relevance because you have literally created a stand-up 2560 for all intents and purposes.
Whether they lost relevance or not doesn't mean they don't exist. There's two separate spacing units. There's the base spacing unit, and then there's the overlapping spacing unit, which is the 2560. Different zones. You're familiar with zones, correct?
I understand what zones are, but what you're doing is you're basically putting multiple straws in the same, for lack of a better word, the same cup.
And that's been permitted by order of the commission,
That's right.
correct?
And
the commission in issuing those orders has found that that does not violate correlative rights when they issued those spacing orders, creating those spacing units, correct?
so section 42 of the Administrative Code
Can you
says,
answer my question, or that I asked?
I don't know the answer to your question.
You don't know whether or
You're-
not the
you're
commission approved those spacing units, and in the approval of those spacing units found, based on evidence presented at a hearing, that the drilling of wells in those overlapping spacing units, the Morris Carson Peak, would not violate correlative rights.
And I'm going to object to the extent he's asking the witness for a legal conclusion or legal opinion.
Overruled.
I do know in every one of those orders, it's the statement of the reservoir engineer and the geologist that comes on says, as a standard operating procedure, approval of this spacing unit will protect or prevent the drilling of unnecessary wells, will basically prevent waste, and will also protect correlative rights. That's the standard rubber stamp answer. And what I'm telling you is that in this case, that is not what's happening.
And anybody who wants to object to that quote-unquote rubber stamp answer and present their own evidence in one of those hearings is free to show up and do so, correct?
Sure.
Okay. And the Anders Sandifer group, did they ever, to your knowledge, show up at any of the hearings where the commission spaced or pooled the Oakdale field?
To my knowledge, the answer is no, because they did not have notice.
Well, they own working interests.
Not in these exceptional locations, they don't, so they were not noticed.
They were noticed for the section line wells to the north, correct? In the north? 2560?
Are you talking about the square 2560 to the north?
Yeah,
Sure.
okay. And did they show up there and said those section line
Well,
wells are
back
going to
up.
interfere?
I'm not certain exactly if the notice in the north followed the notice to the south, then they would have been improperly noticed. Because for exceptional locations, if I understand 18.1 correctly, it requires actual notice. But when I look in the record for the south half exceptional locations, it was simply a circular run in the paper, just constructive notice, not actual notice.
But you don't know for sure.
That's why I haven't looked into the north half, so that's why I said I don't know for certain that they were properly noticed.
Okay. Now, the current, the most recent spacing order for the Oakdale Fields, order number 30745, correct?
I will take your word for that.
Okay. And to your knowledge, in the application, you're familiar with the application that was filed in this docket, correct?
Correct.
Okay. To your knowledge, in that application, was there any request to terminate the base spacing units in the Oakdale Field?
To my knowledge, no.
Mr. Stewart, did you attend a meeting at Continental Resources with, I think, at least some of the Anders Sandifer group?
I did.
In roughly July of 2022?
I did.
And, well, hang on. Go ahead and ask your question before I object.
I'm going to hand you a document, Mr. Stewart, and ask you if it's been labeled by us as Exhibit CR1. Can you identify that document?
Hang on, Dwayne. I'm going to object. In the discovery request sent to Continental in late April, Andrew Sandifer asked Continental to provide all exhibits that it would be using at the hearing. They did not. In their supplemental discovery responses that they filed yesterday at 12:08 p.m., they didn't identify a single document. This is the first time that I'm seeing this document. This is what our Supreme Court time and time again referred to as trial by ambush. So I'll object to the admission of this exhibit. And I'll also object on the grounds that the meeting that took place between Andrew Sandifer and Continental in the summer of 2022 was a meeting that occurred under North Dakota Rule of Evidence 408, which was confidential settlement communications, thus also making this exhibit inadmissible.
Well,
Go ahead.
what I respond to that is this isn't surprise. I think this is their own document, so they either have it or should have it.
It is
And it's
surprising
not
because it
part
wasn't,
of-
sorry, go ahead.
And it's also was not part of, to our knowledge, any settlement negotiations. There were no claims pending, to my knowledge, at that time.
There were claims pending. In May of 2022, my office sent a letter to Continental. That meeting at Continental's office didn't occur under the ether. It occurred as a result of several letters back and forth between my office and the attorneys from Continental. Also, this was clearly prepared well in advance of the hearing, and this is ambush. It was not provided. Continental shouldn't get an advantage. They had Mr. Stewart's report last week. Mr. Bankston was able to prepare a cross-examination with the benefit of this report. I haven't seen this before today and haven't had an opportunity to look at it, to know that they would use it. To say that it was previously provided takes the exhibit out of context, and it certainly was not provided by Continental in response to Andrew Sandifer's discovery request asking for exhibits.
I will note your objections. I'm going to allow the exhibit to be admitted. I would like them passed out, though. if we could.
I wasn't gonna pass them out today. Thanks. Yeah, I got it. Oh, I didn't keep them. I need mine. I got one, I think, in here somewhere. No? Oh, yeah, I got it right here. I'll give you a chance to look at that exhibit, Mr. Stewart. Let me know when you're finished.
Okay.
Okay. Ed, are you familiar with this report or this document?
It looks vaguely similar to one that I prepared previously, almost 2 years ago.
Okay, so that you prepared this document?
I did not prepare this document. Continental prepared this document because you just handed it to me.
Okay, so you prepared a similar document?
I prepared a similar document.
Okay, if you look through this document, can you tell me, you just go through page by page and tell me what portions of this document you prepared?
I will, do you want me to stipulate that it looks similar to a document that I prepared in its entirety?
Yeah.
Without having my document here to compare page by page by page, I cannot attest to the fact that this is exactly equal to my document.
But it appears similar.
It appears similar. That I can attest to without, comparing it side by side.
Okay, turn to page 5. And does this page 5 appear similar to an analysis that you prepared and provided to Continental?
Yes.
Okay. And in this document, in this page 5, what you've done here is concluded, and it's stated as conclusion number 1, that the Middle Bakken and the Three Forks first benches communicate post-stimulation.
Correct.
And that conclusion was based on your analysis of the comparison of the production shown on the graphs between the Whitman 234H and the Whitman 334H wells.
Correct.
Okay. And you said there at the top, I believe this would be what you said, was they communicate through though landed in separate benches, correct?
Correct. I made the same conclusion in my interference report previously.
Okay. And that was page 22 in figure 19, correct?
I think I would just point out Andrus Bates 21, the penultimate paragraph on the page, where I say, thus the Whitman 2 proves interference can occur not only between wells in the same zone, for example, the Carson Peak 4, but also between wells in different zones, for example, the Whitman 3 and the Whitman FIU 13, which at the time the Whitman FIU 13 had not been drilled.
Okay. And when you use the word communication, is that essentially the same as saying interfere or interference?
Yes.
Turn to page 7 of your report, please. And does this page 7 appear similar to the report that you prepared and provided Continental?
They don't have page numbers on here, so can you tell me which two wells?
It's Carson Peak 535 and the Carson Peak 635.
Okay.
Just to clarify, you're referring to Exhibit CR1 and not to the report right now.
Yeah, oh, I'm sorry, yes, Exhibit CR1. Thank you.
Okay. I'm there.
Okay. And does this, the page that you're looking at in Exhibit CR1 appear similar to materials that you prepared for the presentation with Continental?
Yes.
Okay. Now, as I read this, down at the bottom, you say you've expanded your conclusion number 1, which was on page 5, correct?
Correct.
And you've expanded it to say that the Middle Bakken, Three Forks first bench, and Three Forks second benches communicate post-stimulation, correct?
Correct.
Okay. And that was based on your analysis of the Carson Peak 535 well and the Carson Peak 635 well, correct?
Correct.
So at least as of this point in time in 2022, you recognize that all three formations, the Middle Bakken, the Three Forks first bench, and the Three Forks second bench, can communicate
Correct.
and do in some instances.
Correct.
Okay, has that conclusion changed between July of 2022 and today?
No.
In your report, which is Exhibit 2, applicant's Exhibit 2,
The interference report.
the interference, in that, you conclude that the Carson Peak 2 well was interfered with by the Carson Peak number 4 well, the drilling, completion, and production from the Carson Peak 4 well, correct?
Yes.
Okay. And in your report, do you attribute the cause of such interference to any other wells?
I did not break out the relative impact between any of the wells.
You
I
didn't
just-
identify any other wells that were the source of the interference in the Carson Peak 2?
Not true. I do.
Okay, tell me where.
I'd like to draw your attention to page 21 of 40, which is Andrus, page 22.
Okay?
This is the Whitman 2 well, and I point on here that, that the Whitman 2 was shut in October of 17 for the Whitman 3 re-drill. The Whitman 2 returned to production August 18 with a step change in W and water oil ratio. So that first step change was due to the Whitman 3 re-drill.
Okay.
I then go on to say, in right below it, that it was shut in November of 18 for the Carson Peak 4 frac. It returned to production February 19 with an even higher water oil ratio. And so that would be indicative of interference due to the Carson Peak 4. And then I go on to say Whitman 2 is shut in March of 2022 for the Whitman FIU frac, and it was returned to production in August 22 with a much higher water oil ratio. So this right here in this interference reports points out there are multiple wells interfering with the Whitman 2.
And you've identified the well from the Whitman unit, correct?
I don't think I understand your question. When you say
Okay, you said there were multiple wells.
the Whitman 3, the Carson Peak 4, and the Whitman FIU 13. Those are the three wells that I referenced on interfering with the Whitman
Okay.
2.
Have you, in your report, do you identify any other wells in the Carson Peak unit that you say could have caused the interference in the Carson Peak 2 well, other than the Carson Peak 4 section line well?
I do not.
Now,
I did look at it, though.
you looked at, so I assume, is that in your report?
It is not, because it's not germane to the conclusion of the report. I'll give you, for
Doesn't
example.
support the conclusion in your report.
No, that's not the point. If I draw your attention to figure 12.
Well, that's not my question.
Well, you're asking me if I looked at it, and the answer is yes, but the GOR performance in the Carson Peak 7, which is on the other side of the Carson Peak 2, continues to ramp up when the Carson Peak 2 GOR is falling down. So that shows you that those two wells, even though they're proximal to each other, they're the two closest wells in the middle of Bakken and Carson Peak, they're behaving they're behaving dissimilarly. So I looked at it, but because it's not showing interference, that's why I didn't make it into the interference
Okay,
report.
so the Carson Peak 7 well, you've eliminated, you say there's no interference between that well and the Carson Peak 2.
It's not showing an indication of strong interference or any interference.
No interference.
That's the conclusion.
Okay. All right, let's talk a little bit about the Carson Peak 2 well. That was drilled in 2010, correct?
Hang on one second. I'll tell you what. Carson Peak 2, I don't know if it was drilled in 2010. I can tell you it came online in 2011. So
Okay.
I don't contest that it was drilled in 2010. I just know for certain that it came online in 2011.
Okay, 2011 put on production.
Okay.
Okay. And that's a Middle Bakken completion, correct?
Correct.
Okay, now if you look at figure 10 in your report,
Correct.
it shows that the Carson Peak 2 well is located 1,320 feet from the west line of that section, correct?
Correct.
Okay. Now, let's look at the Carson Peak 4 section line well. When was that well put on production?
June of 2019, it was turned in line, if I'm not mistaken.
Okay. My note shows February 2019, but close enough.
I won't, I'll take your word for it, but I think it was
Okay.
more middle of the year.
And that's also a Middle Bakken completion, correct?
Correct.
Okay, now what is the location of that well with reference to the west section line of section 35?
The Carson Peak 4
Carson Peak 4 section line.
is basically about 220 feet inside the west line, line of section 2.
Okay, so then the distance between the Carson Peak 2 well and the Carson Peak 4 section line well is approximately 900 feet.
Roughly. Yeah, the blue lines that are vertically running through here are spaced every 6
I'm
feet.
sorry, no, 1,100 feet, 1,120 feet.
Roughly.
Okay, now I'd like you to take a look at the Carson Peak 6 well. Okay? And that well was drilled in 2018 and put on production in February of 19, correct?
I just have 2019. I don't have the month.
Okay. Well, if I say it was put on production in approximately February of 2019, same as the Carson Peak 4 section line well, would you have any reason to disagree with that?
I won't take strong exception to that.
Okay. Just slight exception.
Without having the actual data in front of me of what month it is, I can't attest to it.
Well,
When you're asking me to attest to
that's fine.
something that I don't have the data in front of me to verify.
The Carson Peak 6 well, what's the location of that well in relation to the west line of that section?
It's about 1,200 feet inside the west line.
And so how far away from the Carson Peak 2 well is the Carson Peak 6 well?
In map view or in distance?
Distance.
I'd have to calculate to know what the actual linear line is between the two. But I'm
If I say it was 153 feet,
you're looking at it in map view. You're looking at it just from the top down, but you got to remember it's landed in a deeper zone. So even though it looks vertically only about 150 or 200 feet away, that's different than a well that's in the same zone that's spaced over here. You've got to calculate the Z, which is different from just XY.
okay. Well, just vertically, 153 feet apart, subject to any change to that based on depth.
Correct.
Take a look at the Carson Peak 5 well.
Okay?
And that well, again, like the section line well, the 4 and the 6 was drilled in 2018, correct? 19, sorry.
Hang on. I assume it is because, yes, because the 5 and 6, 7 and 8 would have been drilled in about the same program.
And it was put on production in March of 19?
Standard exception apply. I've got 2019 in my data right here, so I won't take strong exception to that statement.
Probably put on production the same time as the 4 section line well, the 6 and the 5. Fair enough?
Within round off.
Okay. And that Carson Peak 5 well is a Three Forks second bench completion, correct?
Correct.
Okay. How far apart from the Carson Peak 2 well is the Carson Peak 5 well on the surface?
660 on the surface plus whatever in Z you would add to it.
Okay. And the Z would be the difference between the Middle Bakken and the Three Forks second bench?
Correct.
Now, in your report, you do not attribute any interference of the Carson Peak 2 well to the CP 6 well or the CP 5 well, correct?
Correct, for the same reason as I don't attribute it to the CP7, which is the fingerprinting of the GORs.
Yeah, where is that in your report?
It's not in there. I didn't put negatives into the interference report.
So are you saying you looked at it and you just didn't put it in your report, or you looked at it and you said there's no interference?
I looked at it, it did not look germane, so it didn't go into the report.
What do you mean by germane?
Because of the fingerprinting and its GOR behavior, it doesn't look like it's interfering.
It's not germane to the conclusion that you wanted to come up with, that all the interference was attributable to the Carson Peak 4 section line well? Is that right?
We're specifically looking at the exceptional locations. If there's interference between the 2, the 3, the 5, and the 6, there's no correlative rights harm.
Oh, so there could be interference.
Oh, absolutely. But there's no correlative rights harm.
What do you mean by that?
Because Andrew Sandifer is spaced in the 2, the 3, the 5, the 6, the 7, the 8, the 9, the 10, the 11, the 12, the 13, and the 14. So interference between those wells has zero impact to correlative rights. Because one well that sucks from the other well, Andrew Sandifer is completely indifferent if well number 1 or well number 2 takes it, because they have a working interest in both. Where they're not indifferent is when you have an offset well where they have working interest in the Carson Peak 2 and they have 0 in the Carson Peak 4. Now when you have interference, now you're harming correlative rights. So I didn't look at interference where there was no harm to correlative rights.
So, well, wait a minute. Correlative rights are correlative rights, correct? They exist regardless of who owns an interest in a well.
Okay?
Do you agree?
Sure. And what I'm saying is that Andrew
and
Sandifer
that's-
is indifferent to which
you
well
answered-
the straw sucks it from.
With all due respect, you answered my question. I didn't ask another one. If your counsel wants to follow up, you can.
Well, with all due respect, let the witness answer his question. Let the witness finish his answer before stepping
Okay.
on him.
Proceed.
Okay, thank you. Okay, so in your report, your goal was to identify interference only, as you claim, caused by the Carson Peak 4 section line well.
No. My goal was only to identify interference that harms correlative rights.
Harms correlative rights of your clients.
And not just my clients, I'm certain there are other working interest owners in the stand-up 2560 that are harmed as well.
There are also working interest owners in the overlapping spacing unit in the South 2560, correct? Correlative rights are agnostic to who owns the oil or gas, correct?
That's a fair statement.
Okay. So correlative rights relate to production from the unit, the spacing unit, as a whole, regardless of who owns that molecule of oil or gas, correct?
Correct?
Okay? And so the goal is to produce the wells within the spacing unit in a manner in which will not harm correlative rights of all the owners in that spacing unit, correct?
So your overlapping spacing unit came second.
Second, first, whatever.
The stand-up 2560 preceded the overlapping. The stand-up 2560 base spacing unit preceded the overlapping spacing unit for the sole purpose of drilling inside the setbacks.
And the stand-up 1280 base spacing unit preceded the stand-up 2560
And-
overlapping spacing
And
unit,
those
correct?
wells were contributed to the stand-up 2560, as I've already testified.
Wait. Let me ask this question. So the well that's drilled and is producing from the base spacing unit, right? In the Carson Peak.
Okay?
Do your clients receive any revenue from that well?
Talking about the 44? This
Yeah.
figure 10?
Yeah.
No, because when the request was made for the stand-up 2560, both 1280s from Morris and Carson Peak were contributed. And the request was not to dismantle the 1280 and not to reallocate the production from those two 1280s.
Well,
They were left alone.
Okay, well, the 1280 still exists.
Exactly, but
No.
those wells were contributed to, they counted as, there were 6 wells. When you do a stand-up 2560, you have 6 wells that were required minimum according to the order that came out, and it's in my report. And I'll draw your attention to it. On page 6 of 40, Andrus Bates number 7. This is basically from Order 14496 in April of 2010. This is a commission order. I'll draw your attention to what's bolded in 1 Bravo, 1B. A minimum of 6 horizontal wells must be drilled and completed. And then I'll draw your attention to the last. Previous horizontal wells drilled on a 1280 drilling or spacing unit qualify as one of the 6 horizontal wells required as development in a proposed 2560. The 44 well that you're referring to was contributed. It was credited towards the 2560. They just didn't unwind it and reallocate that.
What do you mean credit? I don't understand that.
It qualifies as one of 6 wells.
Order 14496 was a general order applied to the Bakken Pool as a whole, where the commission authorized the creation of 2,560 acre spacing units in overall, correct?
That's right. And when
And there's a separate order that created the Morris Carson Peak 2560 spacing unit, correct?
correct.
And that order doesn't say anything about contributing the base spacing unit well to the Morris Carson Peak spacing unit, does it?
Actually, it does, because when you look at the pictures shown, the Continental witnesses testified that there were 6 wells that were going in, and they actually map and show the Morris 1 to the north and the Carson Peak 44 to the south, and they show the 4 more additional wells that are going to be used to develop that stand-up 2560.
Well, the base spacing unit remained in effect after that order was issued, correct?
I do not dispute that, and that's my point is that you've got coexistent base spacing units.
And that's the way it's done today, correct?
Correct.
In fact, your clients, the Carson Peak Morris spacing unit is an overlapping spacing unit.
No, that is not. The overlapping space units only apply to exceptional locations.
Where do you get that?
From when you read 430203.18 and 18.1 in conjunction.
Anywhere else? Other than those 2 regs, do you have any other source for that conclusion?
I do not.
Okay, thank you. So, would your testimony today be the same with respect to your alleged interference of the Whitman 2 and the Whitman 3 by production from the Whitman 13 section line well, that you only looked at wells that your clients didn't own an interest in as far as the cause of the interference?
That's a fair statement.
Okay. You completely disregarded any wells where your clients did own a working interest.
Once again, if you
Is that, you
have,
can answer my question, then you can explain.
repeat the question.
Okay, so you didn't look at, or you didn't look at any wells where your clients own a working interest as being a potential cause of the interference of the Whitman 2 and 3 wells from the Whitman 13 section line well.
I looked at, and if it looked like there was no harm to correlative rights, it was not included in the report.
Okay, and you're defining harm to correlative rights as a well in which your clients don't own an interest.
A complete absence of interest.
Correct.
So production that is sucked away into a different straw with no interest basically creates harm. If you have this is the reason why you have unitization, and this is the reason why you have homogenization of interest across fields, so that the working interest owners are completely indifferent and preserved, their correlative rights are preserved, so you don't get into the situation of we worry about which well sucks which molecule.
So the working interest owners should be indifferent when you're considering spacing and pooling, correct?
In the same spacing unit, absolutely.
Okay. Let me ask you to look at your report. You did a gun barrel plot, correct?
Figure,
I'll find it. Figure 9,
okay.
page 15, and figure 10, page 16. Let's look at figure 10, because they're the same, other than figure 10 is updated to development as of February 2022, correct?
Yes, sir.
Okay. And in that gun barrel plot, the horizontal, if you look at it horizontally, it covers 2 miles, correct?
Correct.
From east to west. And vertically, though, the scale is different, correct?
Correct.
And down below, you made the statement, formation thickness, vertical exaggeration equal 40.
Correct.
Okay, what's that mean?
What that means is you've exaggerated it to show scale and to actually review this diagram. I've exaggerated the vertical scale. So if you look at the top of the upper Bakken Shell to the base of the Three Forks 4, that's roughly, I'm rounding, about 300 feet gross. And so if you were to actually measure east-west with a ruler, compare that to the vertical here, you'll see that that ratio is about a factor of 40 between the two to account for the vertical exaggeration.
Okay, right, because the Three Forks first bench and second bench aren't a mile thick, correct?
Correct.
So if you were to plot the Carson Peak 6 well on this gun barrel diagram and use the same scale that you used horizontally, where would that well be located?
I don't think I understand the question.
Okay.
It's shown in,
Well, it'd move, wouldn't it?
well, the whole thickness would shrink like this.
Right. And so as the thickness shrinks, the dot that indicates where the Carson Peak 6 well moves up.
Sure.
Okay. And how close in vertical distance is the Carson Peak 6 well to the Carson Peak 2 well?
Based upon, it'll be about 100 feet, more or less.
Okay.
Maybe a little bit more.
Okay. And the same question with respect to the Carson Peak 5 well and the Carson Peak 2 well. What's the vertical distance?
It's going to be 150 plus. I'd have to go back and look. Just eyeballing it 150 to 200 on here.
Okay, so if you put it on if you removed the vertical exaggeration, they'd be sitting right underneath virtually the Carson Peak 2 well.
No, the 6 would be a couple hundred feet to the west, and the 5 would be 660 feet to the west.
And slightly below.
And slightly below.
Okay. Now, this vertical exaggeration, your gun barrel diagram appears other places in your report, correct?
Correct.
And, for example, pages 32 through 39, you repeat that gun barrel plot.
Correct.
And although the note isn't there, it's the same vertical exaggeration that's in Figure 10 contained in those gun barrel plots at pages 32 through 39?
Yes, sir.
Page At page 18 of your report in Figure 13, that refers to the Carson Peak 2 well, correct?
Yes, sir.
And your conclusion that the drilling of the Carson Peak 4 well had a material negative impact on the Carson Peak 2, correct?
Correct.
Okay. There were two other wells that we've talked about were drilled at the same time as the Carson Peak 4 well, correct?
Correct.
The Carson Peak 5 and the Carson Peak 6. And both of those wells are closer to the Carson Peak 2 well than the Carson Peak 4, correct?
Correct.
Much closer, right?
I don't know if I'd use the word much closer. They're closer.
Significantly closer?
No, sir.
Okay. And you've not attributed any interference to the production from the Carson Peak 2 well to the 5 and the 6, correct?
For the same reason I didn't attribute it to the 7.
Because your clients don't own an interest.
No, it's because of the GOR performance.
Now, you're familiar with the term correlative rights, correct?
I am.
And that term in the North Dakota Century Code appears in the spacing statute, correct?
I'll take your word for it.
3808071.
Correct.
And that term correlative rights doesn't appear in the pooling statute, does it?
And I'll just object, the statutes speak for themselves.
They do. I'm just asking him what he knows.
I'll defer.
He's testified to his knowledge of correlative rights and when they're violated and when they're not violated. I assume he'd know.
Well,
If he
respectfully,
doesn't,
you're asking them what a statute says, and the statutes are going to speak for themselves.
I agree.
Sustained.
Okay. And the pooling statute, are you familiar with the pooling statute?
A little bit.
Okay, and that talks about just and equitable share of production,
Correct.
correct? And doesn't say anything about correlative rights.
Just and equitable share of production is a synonym to correlative rights.
Okay, but it doesn't say correlative rights.
Doesn't say overlapping spacing unit either, but we all know what that means.
Would you agree with me that when the commission makes decisions on spacing and pooling matters, that they should take into account the correlative rights of all owners in a drilling and spacing unit?
Yes.
Okay. And when the commission pools those spacing units, they should take into consideration all owners' just and equitable share of production, correct?
Correct.
Now, in your report, it appears to me that you've taken into account the interest of only your clients in determining when correlative rights are violated.
Is there a question
Is
there?
that correct?
That's who engaged me to look at it.
So that's correct.
That's correct.
Okay. I don't have any further questions.
Attorney Broughton, any questions for the witness?
Yes, thank you, Your Honor. You've made a comment a few times that well, let me ask you if I'm understanding this correctly. Is it your testimony that the two stand-up 2560s were contributed to the square 2560?
The square 25, are you referring to the square 2560 in the south half of Oakdale?
Correct.
The square 2560 in the south half of Oakdale was spaced for the exclusive purpose of basically drilling inside the setback areas. That was created, and the way the way they do it is they use equal percentage on both sides of the exceptional location. Hence the reason it's a square 2560 in this case. And so that overlapping spacing unit was formed for the sole and exclusive purpose of drilling those lease line wells. But that acreage in and underneath those lease line wells had previously been contributed to two stand-up 2560s, one covering the east half and one covering the west half of Oakdale Field. Said differently, the stand-up 2560 acreage boundary doesn't stop at the 500-foot setback. It goes all the way to the edge of the governmental section. And so that acreage had already been contributed to a stand-up 2560, and these wells were landed in between wells that were producing pursuant to the spacing order of a stand-up 2560.
Does all of the production from those section line wells, is all of the production from those section line wells attributable to minerals within that square 2560 spacing unit?
No.
So should we change the boundaries of the spacing unit to address that then?
I will defer to legal counsel and the commission on what that effort is, but I think the commission already has a methodology that they have prescribed, which is a two-step methodology for accounting for overlapping versus underlying or base spacing units. So when you have acreage in a base spacing unit that straddles the boundary, as in Dominic and Equinor or in Petrohunt and Garris, the idea that the commission has espoused and what they have opined upon is you take the first step is allocate to the spacing unit for the exceptional location, and then if there are any portions of base leases that extend beyond the boundary, then you do a secondary allocation out to it.
Are you familiar with what the units looked like in the Dominic case?
I am.
And the unit that was outside of the square 2560 was, or the section that was outside of the square 2560, do you recall that being section 24?
In Dominic and Equinor, hang on one second, because I'm getting that and Petrohunt and Garris mixed, conflated in my mind. Do you have a picture that I could
Pull it
refer
up.
to?
Yeah.
If I may, there's a map here, if I hand it to the witness, it might help answer and speed it up. Is that all right?
Yeah.
Yes, please, and thank you. And I would just note for the record that the diagram of the situation in the Dominic case appeared in a couple of the briefs as well, I think, that have been filed, so it's in the record as well.
Okay.
And just, if you don't mind me asking, counsel, is this the Painted Woods field that you're referring to in Dominic and Equinor?
That is correct, and we're looking at a diagram that was figure 3 in one of the briefs on page 4 and shows the relevant units from that Dominic versus Equinor case.
It's actually the application, Andrew
Okay.
Sandifer's application to the commission.
Okay, great, thank you.
Yep.
So page 4 of the application shows the diagram from the Dominic v. Equinor case. And you're saying that in order to account for correlative rights and ensure that we are protecting the correlative rights of the mineral owners, the commission's procedure is to allocate from that square 2560 to the underlying unit consisting of sections 23 and 24?
think that says section 13.
13 and 24, sorry.
The first step would be to the square 2560, and in this case, section 13 would receive 25%. And then step 2, based upon my understanding of the commission's orders, right, is that 25% then gets fully allocated across sections 13 and 24. So in this case, it'd be half to 13 and half to 24. So you'd end up with half of a quarter, so an eighth and an eighth of the total production from this lease line well drilled here pursuant to the Dominic Equinor case.
Why do they do it that way?
And then I'll just object to the extent that it's calling for the witness to speculate as to why or why not the commission did something.
I'm going to sustain that.
Do you know why the commission does it that way?
I defer to the commission.
Well, I'm asking if you know.
And I'll raise the same objection. I mean, he's speculating as to why or why not the commission does something. Ultimately, that's the purview of the commission, not this witness.
I'm not asking for speculation.
He can answer this question.
Okay. When a lease line well is drilled, when an exceptional location is drilled, it can have an impact upon offset wells in base spacing units, either positive or negative, right? And so the idea is that all owners in the base spacing unit should share in the production or negative based upon that exceptional location. So you're basically keeping the base spacing units ownership indifferent as to which straw, for lack of, I'm going to use the word straw for the well, sucks the molecule out of the reservoir because it's a common source of supply.
And so based on the fact that there's an underlying unit in 13 and 24, you're saying those therefore are part of the common source of supply from that 2560?
When they spaced 13 and 24 originally, production on 24 will be deemed for all practical purposes as production anywhere on 13, and the converse is true. Production on 13 is deemed for any and all practical purposes being production anywhere on 24.
And that's the reason that we allocate outside of the 2560 to 24?
I can't speak for the commission, they speak for themselves, but that is my understanding why they do that.
And there's no base spacing unit for 14 and 23, is that right?
I do not know because that wasn't addressed in the briefings that I've read for Dominic and Equinor.
And do you believe that you allocate production to section 24 based on that language in the statute that requires you to treat production as if it is a well on the unit?
Yes.
And not because the interests in section 24 are necessarily actually being drained by that section line well between 11, 14, 13, and 12?
So in this case, you've got wells running, if I understand the stick diagram in Dominic v. Equinor, I'm pretty certain they run north-south that straddle 13 and 24. So because you have a take point that straddles 13 and 24 here, that lease line well is going to interfere with a well that mineral owners in 24 have a piece of. And because these mineral owners have a piece of that well, when that production goes out of this lease line well, every barrel it captures is that they don't participate in is a barrel that could have been produced from their base spacing unit well.
How do you know that?
You look for interference, you look for drainage. We see right now water-oil ratios change, we see gas-oil ratios change, we see production decline curves change. We see interference, right? Now, whether it's a 1-to-1 or if the degree of production interference is 1-to-1 or 0.5-to-1 or 0.75-to-1, it doesn't matter. The point is that there has been an interference. And so to maintain the status quo, you allocate across 13 and 24.
But if you don't connect that interference to an actual volume of lost production, you can't allocate anything accurately, can you?
So you're basically asking if you don't, are you asking if you don't see interference immediately? Because what I will tell you is sometimes what I've seen in some of these wells is post-drilling, there's a step up in production. And we saw that, I think, in Petrohunt v. Garris, where the lease line well there, post-stimulation, all 7 or 6 of the 7 offset wells actually stepped up. And the commission asked, okay, you had an instantaneous step up, which is indicative of connectivity, continuity of reservoir, common source of supply. What did it do to reserves? And what I will tell you is it's taken me sometimes 5 years of performance to actually measure the full impact of that interference. And so you can't draw a conclusion on a short-term change in production to long-term. You got to have long-term curves. So your comment of, well, you don't see interference. We don't see interference when? 6 months, 12 months, 3 years? These are really, really low-perm reservoirs, and the interference might take years before you see that interference based on the pressure transient to propagate across the reservoir, because we're talking about micro-Darcy and nano-Darcy, low-Darcy perm reservoir. It takes time to see it. So the assumption is Section 13, if there's production being attributed to Section 13, you attribute it to the entire spacing unit, because those barrels that are being drained is coming from that base spacing unit.
Would you attribute it to a well that was drilled 200 feet to the east of sections 13 and 24?
If you're 200 feet east of, what are you talking about, Section 13? You talking about over here?
600 feet.
If you're 600 feet, you're outside the setback. And so the commission, I don't envy them, they have to balance correlative rights and capture, right? So the 500-foot setbacks that are run parallel to is basically where they've landed between basically kind of weighing how much off-lease drainage are we willing to allow versus maximizing production and recovery out of the reservoirs.
Which is the exact same justification for drawing a line around that 2560, right?
I don't follow.
And I'll just object to the extent that I believe this commission, the U.S. District Court in North Dakota, and the North Dakota Supreme Court have already made decisions with respect to Dominic, and I don't know that that's why we're here today, is to relitigate that. So to the extent that council is rehashing Dominic, I don't know that it's relevant here.
I'm the counsel from Dominic, and his application has the diagram from my case, and it's simply being used to illustrate the principles of reservoir dynamics that we're here talking about today, and it's pertinent for the same reason Mr. Swanson put in his application. That's why we're here.
It's pertinent because the commission spoke to this in their amicus brief. We have several court rulings on it as well, and it's being used to show there's a parallel between what's occurring and what the court and commission have said in Dominic and what the requested relief is here.
And Darcy's law applies to the entire Bakken.
I'll allow him to answer the question.
Can you repeat the question?
Would you allocate to a well, well, I'm going to start back a second. Would you allocate to a well that is 600 feet to the east of sections 12 and 13 from that section line well?
So, let me clarify. So if you've got a well landed 600 feet inside, so basically you're saying it's in 7 and 18,
Correct.
and it's 600 feet from sections 12 and 13. The answer is no, because that would be outside the drilling setback of 500 feet.
What if you saw interference there?
At that point in time, that is a prescribed legal location when you're outside, when you're beyond 500 feet.
Just like the boundaries of the spacing units are prescribed legal locations.
When I use the word prescribed, I'm following what is a base spacing unit definition in section 18. Are you talking about an exceptional location that's inside, or are you talking about a location, a drilling location that's outside of a setback?
How are you describing the setback?
The setback in this case at Oakdale or most other places is generally today about 150 off of the heel and the toe and roughly 500 parallel to the wellbore from a section line boundary.
Based on the order for that spacing unit?
Correct?
Would you agree that the way we protect correlative rights is to ensure that every owner within a spacing unit receives their just and equitable share?
Yes?
Nothing further.
Any questions from the staff?
Dwayne, I got, kind of, I guess, maybe my understanding clarification question. I'm gonna ask to go to your page 18 or your 40 on your report, figure 12. I believe that will help me with what I'm gonna ask you.
I'm there.
Okay. And again, I'm hoping it's more clarification, but in what you state in the red box, the yellow with the red wording there on the right of that figure, because it was noted that the increase in GOR and WR, that means that there was interference. Am I understanding what you're saying there correctly?
Yes, sir. And the reason why is because just because you have a precipitous drop in oil production, that could be to a pump failure. That could be to a hole in the tubing. That could be due to a whole host of other situations. What you don't expect to see with a pump failure or a tubing hole is upon returning to production, GOR skyrocketing and water oil ratio step changing. And so those telltales associated and concurrent with the precipitous drop in oil production is indicative and demonstrative of interference.
So to add again to what I'm asking there, essentially what you're stating is that due to the rapid incline in GOR and WR, that's what you're referring to as interference. I mean, the Bakken does have an increase in GOR, so it's well known.
Correct.
It's more so the,
Yeah.
I guess for lack of a word, the speed of which that well's GOR is increasing is what you're feeling is the interference.
Correct. And if you also notice the water oil ratio, it was a step change up to about 1.5, 2. It's obviously fallen back. It's basically declining again. That's the purple squares. I apologize. I tried to make these as big as I could, and it's tough to get all that data in here. But the water oil ratio took a step change up, and the water oil ratio has been it's falling off and coming down, but it's still at a level higher than pre-shut-in.
Okay, thank you.
Mr. Stewart, you've been referring to these lease line wells as exception or exceptional location wells. You're not stating that the commission should have permitted these as exceptional location wells, you're just stating that they're within a setback.
That when you're inside that setback area, that's an exceptional location, but you create a unit around that exceptional location in section 18. So each well that's drilled is formed a spacing unit around it. When you look at section 18, there's a spacing unit, and so the spacing unit that gets defined for some of these exceptional locations, essentially you kind of use equal area on both sides of it. But the idea is that it's a secondary spacing unit that has been created. Overlapping is a really good term on top of base spacing units.
So the lease line wells are drilled pursuant to a spacing unit the commission established.
Yes, sir.
And on exhibit, or table 6, page 27 of 40, you had previously testified specifically about the GOR line and the Whitman 2 parent well and the Carson Peak 2 parent well. You indicate they had a flat GOR for an extended period of time. And then you have, in the two interior columns, you have ramp from 1,000 to 3,000 in a period of time. Is that the GOR of the well you listed at the top of that column, or is that the GOR for the parent wells?
For the well listed at the top of the table.
Okay, thank you.
Mr. Swanson, any redirect?
Just a few, thank you. We've been talking about Dominic, and you were asked about Dominic. The commission's amicus brief to the Supreme Court, I'll note, is Exhibit A to petitioner's application. You were asked questions about an overlapping spacing unit and a section line well. So I want to ask you, when the commission writes in their brief at paragraph 9, it is therefore the commission's practice to allow lease line horizontal wells to be drilled on a common spacing unit boundary between existing spacing units by establishing an overlapping spacing unit that contains areas of similar size on either side of the common spacing unit boundary. Does that comport with your understanding of the purpose of section line wells when you're preparing your report?
Yes, sir.
Okay. Paragraph 20 of the commission's amicus brief, and Dominic, quote, "The purpose of these overlapping spacing units is to allow for the drilling of a lease line well that otherwise would not be possible to drilling setbacks," end quote. Does that comport with your understanding of overlapping units as reflected in your Exhibit 2, your report?
Yes, sir.
You were asked questions about base unit, as in singular versus plural. So let's keep playing the greatest hits. Paragraph 24 of the commission's brief, and Dominic, quote, "The commission believes a lease line horizontal well in an overlapping lease line spacing unit will recover oil from lands within the setback area of the underlying base spacing units," plural. Do you agree with that?
Yes, sir.
The commission goes on, same paragraph 24, "Without the lease line horizontal well, the oil would be recovered less efficiently or not at all by the horizontal wells in the base spacing units. Therefore, all pooled interest owners within the base spacing units should receive their equitable share of that oil, not just the interest owners in the sections located within the overlapping lease line spacing unit, but all interest owners in horizontal wells in the base spacing units," plural. Do you agree with that?
Yes, sir.
Paragraph 25. You've talked a lot about interference and impact this morning. Paragraph 25 of the same brief, quote, "The commission also believes the lease line horizontal well may cause positive or negative impacts to all wells in base spacing units shared by all interest owners within the base spacing units." Do you agree with that?
Yes.
Is that what you concluded and saw in your report when you examined the impacts from the Carson Peak 4 and Whitman FIU 13 well?
Yes.
With respect to the questions you were asked on actual notice, and if you don't know, Dwayne, you don't know, but to your understanding, did the Andrews-Sandifer Group and any of their group members receive actual notice from Continental with respect to the drilling of the Carson Peak 4 or Whitman FIU 13 section line well?
The answer is no, they didn't, because of Continental's information that they submitted with the case. That only shows they did constructive notice.
Okay, and you're referring to the case file for both those wells that the commission has?
Correct.
With regards to that meeting in, was it in Oklahoma on July 20th, 2022 that Mr. Bankston asked you about? Was that where it was, in Oklahoma City?
It was in Oklahoma City.
Okay. You were present at the meeting?
I was.
Who else was present at the meeting?
Melissa Sandifer, Thurman Andrus, Mr. Ham, Harold Ham, and Mr. Bob Haggins. I hope I haven't butchered your last name. So.
Who were both at the hearing here today. Let me ask you this. What was your understanding of the purpose of that meeting?
We were going up there to basically settle an issue that we had.
And when you mean settle an issue, your understanding was that it was related to the legal settlement or potential legal settlement of the case after communication between Andrews-Sandifer's counsel and Continental's counsel. Is that correct?
Correct.
With respect to correlative rights, you were asked about spacing unit and pooling. I'm going to read you a quote from Highstead versus Industrial Commission, 389 Northwest 2D, 590 ND 186, and Mr. Broughton asked you about it. Quote, "Each landowner is entitled to a just and equitable share of oil or gas in the pool. However, that right is limited by the landowner's duty to all other owners of interest in the common source of supply not to damage or take an undue proportion of the oil or gas from that common source of supply." Does that comport with your understanding of correlative rights?
Yes.
Is there a common source of supply between the underlying spacing unit here at issue and the overlapping spacing unit?
Yes.
the commission, or excuse me, the North Dakota Supreme Court went on in Hysted, quote, "The physical characteristics and reservoir dynamics of the common sources apply and necessitate the use of highly technical, geological, and economic information to determine the extent of correlative rights," end quote. That's effectively what you examined in your report at Exhibit number 2. Is that correct?
Overruled.
Yes.
Have you seen any similar reports in this matter with respect to those highly technical, geological, and economic information? Have you seen anything produced by Continental that's remotely like your report in this case?
No.
Me neither. That's all the questions I have.
Anything further?
Yeah, Mr. Stewart, have the Continental witnesses testified at this hearing yet?
No.
And my understanding is that you were a retained outside expert by the Anders-Sandifer Group to testify in support of their application of this matter, correct?
Correct.
And that's why you prepared a report and submitted it.
Actually, the reason why I started 2.5 years ago was Mr. Andrus asked me to write a reserve report for him as he was doing some estate planning. In the process of doing that reserve report, which is why he had engaged me, I noticed a discrepancy, and I'd like to draw your attention to figure 6,
Okay.
which is on page 10.
Okay.
And so figure 6 on page 10, when I'm looking at this, which is the stand-up 2560, I noticed Mr. Andrus had interest in 3 out of the 4 areas for section line wells. But in the lower left, which is the colored red area, he had none. And there's no difference between Mr. Andrus' working interest in any of these sections between the east half, or the eastern sections, which is on 35 and 2, and the western section of 35 and 2. So whatever methodology you're using for the east half, which is the Carson Peak 14, it should be applicable to the Carson Peak 4 and the Whitman FIU 13. It was a blaring, obvious aha moment, and so when I started asking Mr. Andrus, why are you in the lease line well to the east, but you're cut out of the lease line well to the west?
While you're there, on figure 6, you see the north square 2560 unit lease line wells there in the green. You say Anders-Sandifer has working interest in both lease line wells.
That's correct.
Okay. And my understanding is that in sections 23 and 26 and 22 and 27, you didn't do any interference analysis with respect to the interference, any interference from the section line wells in the north 2560 overlapping spacing unit, correct?
Correct.
Okay. And in fact, the applicants in this case are not asking that any of the production from those north lease line wells be spread to the Morris Carson Peak unit.
That's correct.
And is that because their interest in those wells would be diluted?
No. It's because they have interest there, they have no interest down here, so they're basically asking to be corrected down here.
But if you allocate production from those lease line wells to the Morris Carson Peak unit, their interest will be diluted in those wells, correct?
If the commission makes an order of that effect, or Continental or somebody else were to bring their own petition for that effect, then yes, it would be.
But right now, as it stands, the applicants haven't asked for that, even though it's essentially mirror to the relief they're asking for in the south.
That's correct.
I don't have any further questions.
Anything further, Mr. Bratton?
Just a couple, thank you. We talked earlier about the diagram in Dominic, and I want to use that as an illustration again. But we talked about correlative rights, and I think you made the comment earlier that you would allocate to the unit consisting of sections 13 and 24 because there was a well drilled there. Is that accurate?
And just to clarify, I would allocate to 13 and 24 because of this exception. This lease line well that was drilled right here, it's inside that setback area. So because it's inside the setback area is why I would allocate across here.
And explain that to me, what about the being inside the setback area requires you to allocate to 13 and 24?
So North Dakota is different than other jurisdictions and states. But let me paint a picture for you. If somebody wanted to come drill a well right here, this lease line well in Dominic, right? Because it's encroaching upon that setback area, would the owners in 24 have a right to protest? They're outside the 2560, would they have a right to protest? They would. How do you moot the protest? You allocate the owners in 24 a piece of that lease line well.
Why
That's how you mitigate that protest.
Why do the owners in 24 have a right to protest?
Because production from that lease line well is going to drain reserves from section 13 that's already been spaced in a 1280 right here between 13 and 24. That well is going to take oil that otherwise could be developed by wells that 24 would be in.
But you're not saying that that lease line well is going to drain section 24.
No, it's going to drain section 13, and so the point here is that because any production on 13, because of this base spacing unit, is deemed for all practical purposes as production of anywhere on 24, that's the correlative right feature of it.
Thank you. No further questions.
Attorney Swanson, you can call your next witness.
I have no other witnesses.
Okay. Then Attorney Bankston, you can proceed.
Thank you. Let us get adjusted here.
Sure,
We'll call our first witness.
sure.
Sorry, could we take 5 minutes?
We
Dave,
can.
is that-
We'll go off the record for 5 minutes. Okay, we are back on the record. Attorney Bankston, you can proceed, or, I'm sorry, I recall your name again.
Ms. Schnell. I'm sorry, Ms. Kaiser. That's my maiden name.
Ms. Kaiser, then you can proceed.
Continental Resources would like to call TJ Botchlet as its first witness. TJ, please state your full name for the record.
I'm sorry, let me swear him in first.
Oh, I'm sorry.
That's okay. Please raise your right hand.
Myself.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
Yes.
And I'll wait till
TJ, by whom are you employed?
Continental Resources
And in what capacity?
as a land supervisor of the Williston Basin.
Have you previously testified before the NDIC?
Yes, I have.
Weren't you in fact here last Thursday
Yes.
testifying?
That's correct.
How many times approximately have you testified before the NDIC?
Since 2006, quite a few times.
Okay. In each instance, were your qualifications to testify as an expert witness in the area of petroleum land and regulatory compliance matters accepted by the commission?
Yes, they were.
I would move to certify Mr. Botchlet as an expert witness in the area of petroleum land and regulatory affairs.
and I would object to that for the reasons stated in petitioner's motion to exclude the testimony.
I would object to that, thank you. Object to that based on petitioner's brief and supporting materials, moving to exclude any expert testimony from Continental. The rules of North Dakota Civil Procedure control in these proceedings. Continental did not remotely comply with Rule 26 with respect to the disclosure of expert witnesses. I'm challenged and my clients are prejudiced. I don't have a resume. I don't have a CV. Continental's had a week to go through Mr. Stewart's resume, CV, and report. Andrew Sandifer has not had that same opportunity. My understanding is we have a standing objection, but I do renew my objection to allowing any expert testimony from Continental, and I'll make the same objection now, so I'm not stepping all over Ms. Kaiser's questioning of her witness to the extent Continental is offering any exhibits or witnesses to the commission. This is one of the, if not the most successful oil and gas operator in North Dakota, run by one of the guys who's a leader, if not the most preeminent authority on oil and gas exploration in the country. They have a team of lawyers, engineers, and for them to be able not to follow the North Dakota rules of procedure and disclose properly their expert witnesses and any documents and exhibits prejudices Andrew Sandifer. So I'll make that objection now for the record.
Your objection is duly noted. You can continue with your questioning.
Thank you. TJ, can you describe your current role and responsibilities at Continental?
Yeah, as a land supervisor, I'm in charge of determining ownership, helping out with determining development plans, commission work, acquisitions, divestitures, questions from royalty owners, questions from working interest owners as well.
Okay. And how long have you worked in the Williston Basin in that capacity?
Since 2006, I worked for ConocoPhillips till 2011, and then I've been working with Continental since 2011.
So you're familiar with and responsible for interpreting and applying spacing units and pooling orders for Continental?
Yes,
Are you also responsible for the allocation and production from pooled spacing units to the owners of interest in those spacing units?
yes,
Are you sponsoring any exhibits this morning?
yes. Exhibits L1 through L20.
Okay, let's walk through those. Describe for me what Exhibit L1 is, please.
Sure. L1 is a general locator map highlighting certain spacing units within the Oakdale field operated by Continental in yellow. The Hawkinson unit is outlined in red, comprised of sections 22 and 27 of Township 147 North, Range 96 West. The Morris unit is outlined in green, comprised of sections 23 and 26 of Township 147 North, Range 96 West. The Carson Peak unit is outlined in purple, the lighter purple, and is comprised of sections 35 and 2, section 35 of 147.96 and section 2 of 146.96. And the final unit there is the Whitman unit, outlined in the dark purple, which is comprised of sections 34 of 147 North, Range 96 West, section 3 of 146 North, Range 96 West.
Thank you. Let's move to Exhibit L2.
All right.
Can you describe this for the commission?
Yeah. I want to start in the middle of the plat today. The green crosshatch on the plat covering sections 22, the west half of section 23, all of sections 26 and 27 represent the applicant's leasehold. The applicants do not own any leasehold in sections 34, 35, 3, and 2. Now that we've covered exactly where the applicants where their leasehold is, we'll walk through their ownership within each one of the base spacing units. Starting in the top right, in the Morris base spacing unit, Continental owns approximately a 38% working interest, and the applicants own approximately a little under 8%. And we do have other working interest owners making up the balance of 53%. As we move down to the bottom right, the Carson Peak base DSU, Continental owns approximately 35% working interest, and the applicants do not own any working interest, which leaves the balance of 64% from other working interest owners. And the final unit in this case is the Whitman base DSU. Continental owns a 34% working interest. The applicants do not own any working interest, and the other working interest owners represent 65% working interest.
Okay, I want to back up just a second. You were referring to the red, green, purple, and pink outlined units as base spacing units. Have you read or are you familiar with Commission Order number 33453 in case number 29902, the application filed by Petro Hunt?
Yes.
And in that order, I believe we've heard it here several times today, but the commission referred to something called the base spacing unit. Are you familiar with that?
Yes.
Would you agree with me if I tell you that that order defines base spacing unit as the first spacing unit established for horizontal well development of the spaced lands, typically 320 acres, 640 acres, or 1,280 acres?
Yes.
And so it's your understanding today that the term's base spacing unit, and when you refer to that, you're referring to these 4 units.
That is correct.
Great. Okay, let's go. I think we jumped into it pretty quick this morning, but I think it's important for the commission that we walk through the history of the Oakdale field and how it was spaced. So I will let you talk through that history.
Great. All right. The next set of exhibits, they're going to take a little bit of time to work through, but it's important to show the systematic and time-proven method of Continental for orderly development of the Oakdale field. As we move through the exhibits, they're all laid out in a similar fashion. Each exhibit is representing the year end, and I capture the spacing and pooling information along with additional wells that have been spud in that year. This will start with 2007, and this is early Bakken development, as you can tell from the coplanar well located in sections 24 and 25. The process for developing the Oakdale field started with an application to establish drilling units. This is the first thing a company would do, would be to submit an application to the NDIC to establish a drilling unit. A drilling unit allows for 1 well per 1,280 acre spacing unit, and this would be what you could consider the exploration phase.
And just for clarification, during this time period in 2007, units were typically developed on a 1280 spacing, correct?
That's correct.
Okay. At these hearings that you have listed, did Continental present technical expert testimony at those hearings
Yes, we did.
through land, engineering, and geology?
That is correct.
And are you aware if the applicants objected to or otherwise protested to Continental's recommended spacing in those
They did
hearings?
not.
Did the commission ultimately approve Continental's proposed spacing and or pooling?
Yes, they did.
Okay. Let's move on to L4.
All right. This exhibit is showing year end of 2008. In the top right corner, I'm listing the wells that were spud in 2008, being the Whitman 1134, the Carson Peak 44-2H, and the Morris 1-23H. Continental and Burlington executed on the development previously communicated to the NDIC, and at this time, the initial wells in the Morris, which was actually drilled by Continental, the Carson Peak and the Whitman wells were both spud by Burlington and subsequently turned over to Continental to operate.
At the risk of being redundant, did Continental and Burlington present technical expert testimony at those hearings?
Yes.
And are you aware if the applicants objected to or protested the recommended spacing and pooling?
No, they did not.
And did the commission ultimately approve the proposed spacing and pooling orders?
Yes, they did.
On to L5.
Exhibit L5, let's start at the bottom, showing the spacing application. Continental testified to the Hawkinson 1,280 acre spacing unit to be included in Zone 2, allowing for up to 2 wells, 2 horizontal Bakken wells. And then in November of 2009, Continental spud the Hawkinson well. In addition to the spacing applications, Continental also submitted an application to pool the Whitman and the Morris spacing units. So as of right now in 2009, each 1,280 acre base DSU has an existing horizontal well spud in it.
And at this time, based on your earlier testimony, the applicants would have had an interest in the Hawkinson and the Morris units only, correct?
That is correct.
Okay. At these hearings listed on L5, again, did Continental present technical expert testimony at those hearings?
Yes, we did.
Are you aware of any objection or protest from the applicants to Continental's recommended spacing and pooling?
No, they did not.
And did the commission ultimately approve Continental's proposed spacing and/or pooling?
Yes, they did.
Thank you. And to exhibit L6.
Exhibit L6, we'll start with the spacing in the middle due to the timing of this. So in early 2010, Continental submitted an application requesting 4 wells per 2560 be allowed in the Carson Peak and Morris unit. Then Continental spud the 4 Carson Peak and Morris units later in that year. In addition to spacing the Carson and Morris Peak, we also asked for the Hawkinson and Whitman to be spaced on 4 wells per 2,560 acre spacing.
And why did Continental shift from developing this field on 4 individual 1280s to 2 2560s?
Yeah, so at this time, Continental was pushing the limits of the drilling rigs and hyper-focused on drilling the best wells we possibly could. And one of the innovations at this time was our EcoPad design. The EcoPad design provided cost savings, reduced setbacks, allowing longer laterals and more efficient drainage. These are essential inputs for drilling the best wells possible. Also, I just want to point out, it's kind of hidden under the labels here, but the Killdeer mountain range is also running right through the middle of our spacing units. So by drilling on a 2560, it allowed us flexibility to move our surface location to optimize our operation throughout the life cycle of the well. And developing these wells at this time on a 2560 allowed for uniform production.
And there was nothing from the production, and we're going to have an engineer testify more to this later, but there was nothing in the initial production from those 4 1280s to indicate that there was anything but uniform production.
That is correct.
And I'm going to object to the relevance of this testimony. There's, I don't believe, a dispute as to the existence of these spacing units. So I don't know how they're relevant to the issue of allocation of the CP4 and Whitman FIU 13, which is a question before the commission. So Andrew Sandifer will stipulate that these spacing units do exist, the 1280s and the 2560s, because the commission knows they exist. So I'm going to object to the relevance of this testimony and this line of questions.
I'm going to let him answer.
Thank you. And just for clarification, you have read the application that's at issue here today, correct?
Yes.
Does the orange, so does the eastern 2560, the Morris Carson Peak orange outline, does that depict what applicants have consistently throughout their pleadings identified as the underlying spacing unit?
Yes.
And does this fit the definition that we discussed earlier of a base spacing unit as described in the Petro Hunt order?
No, it does not.
Why not?
The base unit described in that order is the first spacing unit established for horizontal well development, typically 320 acres, 640 acres, or a 1280. And in this case, it would be the individual 1,280 acre spacing units.
Did these 2560 spacing units terminate those base spacing units, or do those still exist?
They still exist.
Okay. Again, did Continental present technical expert testimony at all of those hearings for these 2560 spacings?
Yes, we did.
And are you aware if the applicants objected to or protested Continental's recommended spacing and pooling?
No, they did not.
Are you aware whether or not, given their interest in the Morris 1280 unit, did they participate in the Morris Carson Peak 2560?
Yes, they did.
Sorry, and did the commission ultimately approve Continental's proposed spacing and pooling?
Yes, they did.
Okay. Is there anything else about this exhibit that you'd like to touch on?
I just think the last thing I'd mention here on this slide is that Continental requested an additional pooling application for the Hawkinson, Carson Peak, and the Carson Peak Morris unit at the same time
Okay.
this year.
Moving on to L7.
So L7 is demonstrating the continuation of our development plan that we set forth in Exhibit L6. So Continental spuds 4 wells on the 2560 and the Hawkinson and Whitman unit. And Continental also pooled the Hawkinson Whitman 2560 at the same time.
Okay. Is there anything else on this exhibit you'd like to note?
And I'll just object to leading. If she has a question to ask him, that's fine, but asking the witness a broad-based thing, tell me what else you want to note in here. He's leading the witness.
I'll let him answer.
Okay, thank you. Yes or no?
No, not on this one.
On exhibit L8. Let's move on to L8.
All right. So Exhibit L8, I want to draw your attention to the spacing order section of this exhibit. In October of 2012, Continental submitted an application requesting up to 16 wells be allowed in the 1,280 acre spacing unit of the Hawkinson unit.
And why, since Continental had just previously asked to develop the Hawkinson Whitman on a 2560, why did they come back to the commission and ask to infill the Hawkinson as a 1280?
Yeah, so the Hawkinson unit, this is an important unit, not only for Continental, but for the basin at this time. This development plan essentially proved up productive zones in the Middle Bakken and Three Forks benches. This also proved up that reduced setbacks would be warranted. We also had an anomaly in the Whitman number 3 well, and we would not be able to mirror the development as required within the timeline established by the NDIC for 2560 acre spacing.
And you mentioned the information that we gathered, was that was from what?
So when we were drilling the Whitman number 3, we drilled into an anomaly and we had to stop that well at 1,700 feet short
Okay.
and pull out due to high pressure. At the same time, this is also part of the EERC study that was being conducted, which was a 15-well collective development. And then, let's see here, which the NDIC also participated in. Yeah, that's it for that one.
Do you know if the applicants participated in the 1280 development on the Hawkinson?
Yes, they did.
Do you know if at any time they objected to or protested the development of the 1280 at the NDIC?
No, they did not.
Okay, let's move on to Exhibit L9.
Exhibit L9 is essentially where Continental completes the infill development on the Hawkinson unit. So later in 2013, Continental submits an application to drill up to 12 wells in the Morris Carson Peak 2560.
And again, why did Continental decide to drill, to infill this as a 2560 rather than going back to 1280s like it did in the Hawkinson and the Whitman?
So in the Morris Carson Peak 2560, we're noticing uniform production. There's not an anomaly like the one we found in the Whitman unit. We're also continuing to optimize the use of the EcoPad technology, which is drilling from a single pad, reducing drilling costs, completion costs, and environmental impact by centralizing our operations on a single pad. Drilling costs are reduced by utilizing the walking rig, which moves between wells on hydraulic feet that eliminate the need to break down the rig each time it moves from well to another well. Completion costs are reduced by conducting fracture stimulation treatments on multiple wells in one continuous operation, and centralizing those operations and production facilities reduces the size of the pad needed by as much as 75%.
Did Continental present technical expert testimony at those hearings to space this as a 2560?
Yes, we did.
Did the applicants object to or otherwise protest to Continental's recommended spacing or pooling for the 2560?
No, they did not.
Did the commission ultimately approve Continental's proposed spacing and pooling for the 2560?
Yes, they did.
Do you know if the applicants participated as working interest owners in this 2560?
They did.
And again, just to highlight, is the orange highlighted box what you understand as the applicants have defined or identified as the underlying spacing unit?
Yes, that's what they keep referring to as the underlying spacing unit.
Did this 2560 spacing unit terminate the original 1280 base spacing units?
No, it did not.
Okay, let's move on to L10.
All right, so on Exhibit L10, I want to highlight the rules and procedures of the NDIC and the time-tested and proven procedures. The Whitman 3 lateral was cut short due to some type of anomaly in the formation resulting in unexpectedly high pressure. So as a result, the NDIC has a process for handling wells that don't reach full TD and to establish the appropriate spacing. In this case, this would be what would be considered an exception location, as previously mentioned. In this case, the NDIC required Continental to come to the commission and commit to a development plan to re-enter the Whitman number 3 well or drill a replacement well, which ultimately we provide testimony, and we actually were granted an exception or a extension at this time just because that Whitman number 3 well was still producing and the pressures hadn't come down to a level that we could operate with.
So it's possible that the commission would not have allowed us, even if we wanted to develop the Hawkinson Whitman on a 2560 going forward.
Oh,
I'm going to object to the extent it calls for him to speculate as to what the commission may or may not have allowed Continental to do.
Sustained.
Okay. Did the commission ultimately approve Continental's proposed plan to re-enter the Whitman 3?
yes, the NDIC ultimately decided in their order that to best protect correlative rights, the spacing for the Whitman number 3 well should remain the stand-up 2560 acre spacing unit.
Okay, let's move to Exhibit L11.
All right. Exhibit 11, Continental is preparing at this time for what we consider our ultimate development plan, where we increase from previous density of 12 wells per 2560 up to 26 wells per 2560 in the Carson Morse spacing unit. And then we also infill that last Hawkinson well there in 2015.
As to the hearings and orders mentioned on L11, did the 2560 spacing unit for the Morris Carson Peak at this time terminate the base spacing units of the Morris 1280 and the Carson Peak 1280?
No, they did not.
Did Continental present technical expert testimony at those hearings?
Yes, we did.
Did the applicants object or otherwise protest to Continental's recommended spacing or pooling?
Yes. Oh, I'm sorry, what was your question?
Did the applicants
Oh,
object to
no,
or
they-
protest?
No, they did not. I'm sorry. No.
Did the applicants participate in those wells?
They
In
did.
the Morris Carson Peak 2560.
They do participate in those wells when we drill them.
Great. And they participated in the Hawkinson as well,
Yes,
correct?
they did.
And there was no protest at those being drilled on 1280s versus 2560 from the applicants that you're aware of.
No, there's not.
Move to L12.
Exhibit L12 is a continuation of the spacing in preparation for the upcoming development plan. This is the exhibit where Continental is requesting 2 wells per 2560 for the lease line well comprised of the Hawkinson and Morris base DSUs. And in the spacing order, we're asking for 2 wells.
Okay. And so this is going to be, we've heard a lot of testimony today about overlapping and underlapping spacing units. Is this an example of an overlapping spacing unit?
It is.
And what are the base spacing units that comprise this overlapping spacing unit?
That would be the Hawkinson DSU and the Morris DSU.
And did this overlapping spacing unit terminate those base 1280 spacing units?
No, it did not.
Did Continental present technical expert testimony at those hearings?
Yes,
Did the commission ultimately approve Continental's proposed spacing and/or pooling?
yes, they did.
Did the applicants participate in those section line wells?
Yes, they did.
Moving on to L13.
All right. So L13 highlights the additional spacing applications where Continental is requesting 1 lease line well in the 2560 acre spacing unit comprised of the base DSUs between the Whitman and the Carson Peak. Continental also requests 11 additional wells in the 1280 base DSU of the Whitman unit. And lastly, Continental is confirming up to 24 wells per 2560 in the Carson Peak Morris base DSUs.
And why did Continental decide to develop out the Whitman unit on a 1280?
Yeah, so the Whitman unit's still a complex unit with the anomaly in the formation. The Hawkinson unit has already been developed on a 1280 spacing unit, so developing the Whitman on a 1280 is the only equitable path forward.
And so you also mentioned what I'm going to refer to as the Whitman Carson Peak section line well. This constitutes what applicants refer to in their application as the overlapping spacing unit at issue today, correct?
Yes.
And what are the base spacing units that comprise the overlapping spacing unit?
That would be the Whitman base DSU and the Carson Peak base DSU.
Thank you. Okay, let's move on to L14.
All right. So L14, this is where Continental begins our development program, defined through all the previous spacing orders. I've highlighted the 2560 section line wells in blue to show when they were spud in conjunction with the development program. On this exhibit, I've also highlighted the red spacing unit to the west of the Hawkinson Whitman. And I'm highlighting this to show how the NDIC has handled cases in the past. Within the red outline, there is a strong structural component to the geology. And there's also a large disparity in the production between like completion targets. Ultimately, the NDIC terminated and established 2 1,280 acre spacing units.
Do you know why the commission did that?
It has to do with the disparity in production and the strong structural component to the geology.
And is that to protect correlative rights?
It is, yes.
Is that because if one unit has significantly higher production than the other, it would be unfair for that other unit to share in that production?
That's correct.
I know this is a commission meeting, but I'll object. That's leading the witness.
Overruled.
So could the NDIC have likewise downspaced Continental on the Hawkinson Whitman 2560 to 1280s like they did in the Karis Bang.
Yeah, they sure could have.
All right, let's move on to L15.
All right. L15 is a pretty simple exhibit here. In 2015, we just asked for the pooling application for the Whitman and the Whitman Carson Peak base DSUs to be pooled.
Okay, moving on to L16.
All right, L16 highlights the continuation of the full development of the east half of the Morris Carson Peak 2560. And I've listed all the wells that Continental spud there in 2020. This was a pretty big program for us to fully develop this unit out. And then Continental, we're also preparing for the development in the Whitman unit. And as for an additional, which we asked for an additional lease line well between the Whitman and Carson Peak. At this time, we've already drilled one lease line well in there, and we're fixing to come in and infill this Whitman unit. And we have space to drill an additional section line well. So that's what we're doing in this spacing order down in there in the middle.
And to clarify, the blue Hawkinson Morris section line well outlined in the north half of the Oakdale field, that is where the interest of the applicants is located, correct?
That is correct.
They do not own any interests in the Whitman Carson Peak section line well to the south, correct?
Not in the blue outline, that's correct.
Okay. At the hearings for all of these spacings, all of these poolings, did Continental present expert testimony to the NDIC?
Yes, we did.
And did the NDIC ultimately approve those poolings and spacings?
Yes.
Did the applicants object to any of those poolings and spacings at that time?
No, they did not.
To the extent you know, earlier, Mr. Stewart spoke about the notice requirements for these wells. Is there any sort of special notice required for these section line wells?
No.
So for the overlapping spacing unit, as it's been defined by the applicant, also referred to as the Whitman Carson Peak section line wells, would that notice have been made by publication?
That is correct.
And applicants did not object at any of our hearings regarding the southern section line wells.
No, they did not.
Moving on to L17.
All right. Exhibit 17 highlights the conclusion of our full development program. Here we've finished drilling out the Whitman spacing unit, and we've achieved our full development. And then since 2006, we've had approximately 21 spacing applications and 8 pooling applications.
So during that time frame, the applicants never protested or otherwise objected to Continental's development and spacing and pooling of the Oakdale field, correct?
I'll object. That's been asked and answered at least 8 times.
Overruled.
Thank you.
That's correct. They did not protest any of our spacing or pooling applications.
When did the applicants seem to have a problem with how the Oakdale field was pooled and or spaced?
And I'm going to object to that. She's calling for the witness to speculate as to what the applicants may or may not have thought and when they had a problem. And I'll also object to the extent that the witness hasn't shown he has any personal knowledge of that either, based on any conversations with the applicants.
I'll sustain that.
Are you aware of any claims that the applicants made to Continental prior to their application with the NDIC?
In 2022, they sent a letter to Continental.
And how did you come by knowledge of that letter?
It was handed to me, it was sent to me to review and determine what their issues potentially were.
So you were tasked to evaluate the demand that they were making in that letter.
Yes, that's correct.
When was that letter received?
I don't remember the exact month in 2022, but it was well after all the wells were already drilled.
That was going to be my next question,
Yeah.
was that after full development had been achieved at that
Yes.
point?
And I'll object, I don't see the letter here as an exhibit, so the extent he's testimonying as to the contents of that letter, that's hearsay.
I'm not asking him to testify to the contents of the letter, just,
Overruled.
But, fair enough.
is it your opinion that the NDIC made a mistake somewhere or should not have approved any of these spacing or drilling, spacing or pooling units?
No, it's my opinion that Continental adhered to the systematic process for properly spacing and pooling the Oakdale field required by the NDIC. If the NDIC disagreed with Continental's proposed spacing and pooling units, it could have denied or amended Continental's proposals. Since 2006, Continental complied with the NDIC's orders, relied upon those same orders for the allocation of production revenue.
If an interest owner in this field had had a problem with Continental's pooling and or spacing proposals, when would the appropriate time have been to raise that issue?
I'm going to object to the extent it calls for him to offer any sort of legal conclusion.
Overruled.
When we applied for the spacing or for the pooling applications.
Thank you. Moving on to Exhibit L18. Can you explain to me how the production is currently allocated from the overlapping spacing unit, also known as the Whitman-Carson Peak section line wells?
Yeah, so Continental allocates production based on surface acres contributing to the spacing units that are typically comprised of the base spacing units. For example, in the top left, this is the spacing unit or the overlapping spacing unit in question, comprised of the base DSUs of sections 34 and 3 and 35 and 2. And typically the allocation would be 50-50 between the base DSUs.
And do you know from their application what the applicants are requesting the reallocation to look like?
And I'll also object, the application speaks for itself.
Overruled.
Thank you. Go ahead.
No, the applicants have not indicated what their request would look like. There's a couple different ways where there are a couple different ways you could do this, as indicated by the what I've called the imaginary allocation. One could allocate a third to each of the spacing units, or maybe it's 50% to sections 34 and 3, and then 25% to section 35 and 2, and then 25% to sections 23 and 26.
Regardless, if applicants were to be successful, for certain, interest owners in section 35 and section 2 will be diluted, and potentially also interest owners in section 34 and section 3, correct?
That is correct.
Do you know approximately how many royalty owners would be diluted?
Yeah, so in the table in the bottom right there represents 167 royalty owners would potentially be diluted, as well as 43 working interest owners.
And have those royalty owners already been paid some revenue from this section line well?
And I'll object. Earlier, council made an objection that any sort of damages and royalties are not at issue nor the purview or jurisdiction of this commission. So to the extent they're offering testimony as to royalty production, that's beyond the scope of the commission's jurisdiction.
Overruled.
Thank you.
Can you ask your question again?
Sure. Has any royalty revenue been paid on the Whitman-Carson Peak section line wells to date?
Yes, these wells have been set up and have been in pay.
Do you know the approximate amount of what has been paid to the royalty owners?
Oh, I don't have that gross, I didn't add up that column.
Okay,
I don't
no
have
worries.
That gross amount that's been paid.
No worries. Is it conceivable that if applicants were successful in their application, that Continental would have to recoup that revenue from those mineral owners?
Yes, that's correct.
is it possible that the ownership of those minerals has changed since that revenue was paid?
Yes, that's correct.
On what degree, if you know?
And I'll object. I mean, now he's being asked to offer a title opinion and speculate as to what the nature of title might be between owners, which he certainly wasn't disclosed for that in his expert disclosure, and I don't think that's relevant.
No, it's overruled.
Thank you.
So if you look at the production from these section line wells that are in question started in 2018. So since 2018, we've had over 1,000 title changes. That's from divestitures, probates, assignments, acquisitions. We'd have to go back in and try to piece all that back together.
Okay. And going forward, these interest owners would be diluted. They would get less production revenue than they are getting currently.
Yes, that's correct.
Okay, let's move on to L19. Oh, actually, I want to back up real quick. I'm sorry. To your knowledge, have the applicants asked to similarly be diluted in the Hawkinson-Whitman section line wells to the north?
No, they have not.
Under the logic in their application, though, the owners in section 35 and section 2, by their ownership in the Morris Carson Peak 2560, would be similarly entitled to allocation of the Hawkinson-Whitman section line wells to the north, in theory.
Yes, in theory, that's correct.
But it's your understanding they've not asked for that.
They have not asked for that.
Okay, now we can move on to 19.
All right.
So there's been some discussion about the similarity of communitization agreements to the allocation of production to underlying spacing units and overlapping spacing units. What's your understanding of that?
And I'll object. I didn't hear anything from Mr. Stewart this morning testifying as the communitization agreement, so I guess I'm unclear what council is referring to.
Yeah, can you explain where you heard communitization agreements?
Through the discussions in the prior cases in Petro Hunt versus Garris and Dominic versus Equinor, which Mr. Swanson has relied on those briefs and that testimony in support of his argument here today. And so we just wanted to address the issue that has been raised as a reason for potentially allocating production in the manner that Mr. Swanson's clients seek today.
And it's been addressed by the commission and the North Dakota Petroleum Council in their briefing, but nowhere in Andrus Sandifer's briefing do they say that just because the communitization agreements and federal leases are treated that way, that Andrus Sandifer is. Is there a parallel? Well, I guess that's a commission question because it is in the commission and the petroleum's briefing in Dominic, but to be clear, Andrus Sandifer didn't put that out there, nor did its witness.
I would disagree. Mr. Swanson did put that out there. He's relied heavily on the commission's amicus brief in the Dominic case as support for his client's application. So I think it's fair for Continental to address that argument
And
to the extent that the NDIC is going to consider anything from that brief.
And I'll also note, and I hate to keep doing this, but I need to protect the record, nowhere in Continental's responses to Andrus Sandifer's discovery requests or in the witnesses' experts' disclosures does it mention communitization agreements. I'd be testifying as to that.
Your objection is noted, but I'm going to allow you to proceed.
Thank you. TJ, I'll ask you again in case you've forgotten. There's been discussion about any kind of parallel or comparison between how federal acres are allocated production through communitization agreements as comparative to how North Dakota might allocate production to an underlapping spacing unit. Can you discuss that a little bit and kind of what your understanding of that is as a landman?
Yes. So, for example, in this Whitman-based DSU, which is here on the left, the 1,280-acre CA, which was approved in 2008, the the federal acres, I should have marked them a little better on here, but it's the square box in section 34, the smaller one right there. So this is our base DSU. This is the comm agreement that covers that. When we drilled the Whitman-Hawkinson 2560, we also had to have an overlapping CA, which was approved in 2012. I also want to point out that when we drilled the Whitman-Carson Peak section line, we also had to have an additional overlapping CA, which was approved in 2020. And I want to highlight a couple sentences here in this exact CA. This agreement is in conformance with the North Dakota Industrial Commission Spacing Order number 28508 and Pooling Order number 29871.
So in this instance, the overlapping comm agreement fell within our spacing unit.
This is exactly the same outline as the described spacing unit for the section line wells.
Okay. So there was no need to allocate production to federal minerals outside of the spacing unit.
That's correct.
Okay. Moving on to L20.
All right, this is my last exhibit here. This here is a plat that highlights the 1,280 acre spacing units that I think was accurately described at one time as one multi-billion-dollar game of Tetris. And as you can see, most of the 1,280 acre spacing units, or what would generally be called the base DSUs, line up fairly well for overlapping section line spacing units. So what I want to do is I want to take a closer look at the inset plat, and this is the area that's well known as the Petro Hunt versus Garris case. Petro Hunt allocated production to everyone inside the dark blue box, as well as the dashed blue outline as well. I just want to highlight as an alternative that was available where Petro Hunt could have allocated to just the owners in the dark blue box. If you look at the surrounding areas, and I'm talking specifically about section 20, there's an opportunity for a 3-mile section line well to ultimately be developed and protect correlative rights of all the parties involved in section 20. It just comes down to timing. Now, I will say what's traditionally seen throughout the basin is the section line well that's highlighted in orange. The unit highlighted in orange combines two base DSUs to create the overlapping section line wells. And to summarize this slide, I would say that most operators, most allocate like we do using the spacing units defined by the NDIC, and all of them allocate like us at some time.
I want you to explain that to me a little bit more. I think there's perhaps a perception that there is a wrong way or a right way to allocate production to underlapping and overlapping spacing units. Do we allocate production the same way every time to underlapping spacing units?
Yes, unless there is BLM minerals that require a communitization agreement.
And is that the same for, to your knowledge, for most operators in the basin?
And I'm going to object to that for two reasons. One, it assumes facts not into evidence, but in Dominic, the briefing was clear, including briefing from the North Dakota Petroleum Council, that I believe 84% of operators, in fact, allocate interest between underlying and overlapping units differently from Continental.
He can offer his opinion on the matter.
Yeah, so as we see in this plat and in the orange box, most operators, in our opinion, and what we've looked at and determined, is that most of them allocate based on the spacing units, unless there is a circumstance where there's BLM minerals that require an overlapping comm agreement to bring in lands outside of the spacing unit.
And that's based on your personal review of this map and the information available from the NDIC, correct?
Yes.
I do want to ask one more question related to the imaginary allocation. One thing I didn't ask, obviously Continental has a significant working interest in these wells. if Continental were to, or, I'm sorry, if applicant were to be successful in their request, how would that affect Continental's working interest?
Yeah, Continental's working interest actually would go up. We would actually benefit from the overlapping spacing unit being the 2560 instead of the way we did it. Now, with that being said, when we look at our development plans, we're looking solely at the rock and how we're going to develop those minerals. We don't take into account, well, CLR has, or Continental has more working interest in this unit, so let's make it a bigger spacing unit. We're truly looking at the most equitable way to develop these minerals, and the way we did it, we believe is correct.
So Continental's not arbitrarily spacing these units for its own benefit?
No, that's
Okay.
correct.
Okay. So TJ, just to kind of summarize your testimony, do you believe the NDIC made any mistakes in its process?
No, the NDIC got it right. Continental has complied with the orders. The overlapping spacing units comprised of the two base spacing units, the Whitman and the Carson Peak, is exactly as the commission has defined base spacing unit.
Is there any provision in order number 29871 that requires or even supports or implies the reallocation of production from the overlapping spacing unit to the underlapping spacing unit?
No,
Is there any provision in that order, in your opinion, that does not support the reallocation of production from the overlapping spacing unit to the underlying spacing unit?
yes, actually, I'd like to read a couple paragraphs from that specific order. On page 2, paragraph 10, the sole purpose of this order is to pool the 2560 acre spacing unit established by order 28508 for the development and operation of the spacing unit. Order number 28508 established what spacing unit? Oh, that was your, paragraphs 25 through 28 of that order established the 2560 acre spacing unit and authorized the drilling of 2 lease line horizontal wells drilled in a north and south direction. On page 2, paragraph 4, all the owners of interest in the spacing unit shall recover or receive their just and equitable share of production from the spacing unit in the proportion as their interest may appear in the spacing unit. And then on page 3, paragraph 8, this order is limited to pooling and spacing unit described above for development and operation of such spacing unit by the horizontal wells authorized for such spacing unit by order of the commission. And then the last one here is page 3, paragraph 8, the second sentence says, this order does not modify, amend, or alter previous pooling orders for other spacing units. And again, just to reiterate, does not modify, amend, or alter, or require the reallocation of production allocated to separately owned tracts within any spacing unit by any existing pooling order or any pooling agreements.
Last question, TJ. In reality, Continental is here to defend the NDIC, its approved orders and its process, not our decisions in pooling and spacing, correct?
I'm going to object to that question.
He can answer it.
That's correct.
No more questions. I do move to admit exhibits L1 through L20 for the record.
For the same reasons already stated, L1 and L20 were clearly fundamental components of this witness's testimony and report. They did not provide those to Andrew Sandifer until this morning at 8:24, despite Andrew Sandifer's requests in discovery, is incredibly prejudicial to Andrew Sandifer. I have not had an opportunity to review these yet. It's hard for me to cross-examine the witness on them. By contrast, when Andrew Sandifer provided all of their exhibits, 1, 2, and 3, Mr. Stewart's report, Mr. Bankston had an opportunity to prepare a whole line and several pages of questioning for my witness. So I'll object to the admission of exhibits L1 through L20 and the commission's reliance on these exhibits when making any decision in this case.
Your objection is noted. The exhibits are admitted.
Thank
At
you.
this time, we're going to take a 1-hour break for lunch. Return at 1:40. We're off the record. We are back on the record. It is 1:40 p.m. I believe where we left off was, Mr. Swanson, you were going to cross-examine the witness.
Correct. Mind if I call you TJ?
Yeah, that's fine.
Right. Exhibits L1 till 20, did you prepare those?
Yes.
When did you prepare them?
Over the last week or so.
When you say last week or so, before or after Memorial Day, do you recall?
Oh, these would have been after Memorial Day.
Okay. Do you recall specifically, was it more than a week ago? Well, let me ask you this. Had you prepared them before this past Friday, which I believe is May 30th?
I'm going to object based on relevance.
Yeah, and we need to protect the record in the event of an appeal based on the motions to exclude made by Andrus Sandifer, and this speaks to that and the record, whether, I'm assuming whether petitioners here or Continental prevails, we're gonna end up at the Supreme Court, so that's the purpose of asking that question, because they were just provided also to petitioners this morning at 8:24, so I'd also ask for a little latitude and ask him questions about the exhibits.
I'm going to let him answer.
These exhibits were prepared all the way up until midnight last night. That's when I finished working on them.
Is that your typical practice? I heard you testify that you've been a witness for Continental at many industrial commission proceedings. Let me ask you, were any of those proceedings contested out of the, how many did you say you testified at?
I don't know how many I've testified to. Had my qualifications accepted back in 2006. So, yes, I've testified in protested cases before.
Okay, more than 5, less than 5?
Oh, probably more than 5.
As the largest oil and gas producer in North Dakota, is it typically your experience when showing up for a contested hearing to be preparing and finishing an exhibit the night before hearing?
Oh, that's not unusual.
When did you start working on that, though? I don't know that you answered that question.
Guess you could say I started working on putting them together a couple weeks ago. A couple weeks ago.
I noticed during your testimony you had, and there's a manila folder in front of you, and I also noticed a booklet or an outline, and you were referencing and looking at that quite a bit. Is that fair? Did I see that right?
Yeah, those are my notes for the exhibits.
Okay, so during your testimony here today, you were relying upon notes that you had made. Is that correct?
Sure, yes.
Okay. Do you know why those notes that you relied on in your testimony weren't produced in discovery?
I just put them together last night.
So all the notes in front of you you're looking at, you just put together last night?
Yes.
With respect to actual notice in the Andrus Sandifer's interest in the Carson Peak 4 and Whitman FIU 13 well, I didn't see any actual notice sent to them in the well files, on file with the commission for either of those. Was there an actual notice that didn't make it into the well file?
No.
Okay. So was actual notice provided to Andrus Sandifer about Continental drilling the CP4, Carson Peak 4 and Whitman FIU 13 wells?
No, they don't own an interest in those wells.
Okay. I want to ask you, you had mentioned that it's your understanding, and if I misheard you, correct me, did I hear you testify that the majority of operators in North Dakota treat the allocation with respect to underlying and overlapping units the same way Continental does?
And yes, yes, they do.
Okay, are you familiar with have you read the, in North Dakota Petroleum Council's brief in Dominic that was submitted as Exhibit A to Andrus Sandifer's pre-hearing brief?
I have read it, yes.
Okay. Any reason to dispute the statement in the petroleum? Let me ask you this, is Continental Resources a member of the North Dakota Petroleum Council? Do you know?
I'm assuming that we are, yes.
Okay. Do you have any reason to dispute the statement that The North Dakota Petroleum Council is a trade association representing more than 500 companies involved in all aspects of the oil and gas industry, including operators who produce approximately 98% of the oil in North Dakota. Do you have any reason to dispute that?
No.
Okay. I'm going to read you from paragraph 8 in the North Dakota Supreme Court's decision in Dominic. The commission agrees with the reading advanced by Equinor and claims production must be allocated from section 13 to 24. The commission claims the method advanced by Equinor prevents waste and protects the correlative rights of all interested owners. Is it correct to say, to your knowledge, is Equinor's position different from Continental's with respect to allocation between underlying units and overlapping units?
I'm going to object to speculation. If he would like Mr. Botchlet to read that brief. and
I've asked him
make
if
an
he
opinion.
knows. I didn't ask for him to speculate. If he doesn't know, he can just say that you don't know if Continental's position is the same as Equinor's, because what you testified to earlier was that the majority of operators agree with your position. So does Equinor agree with Continental's position?
In some cases, yeah, they allocate wells based on spacing units.
So their position in here, that, let me back up. What units would Equinor allocate an interest that is the same as how Continental does it, that you're referring to?
Well, that would be, we can just look at these exhibits right here. This would be just like here, we'll just flip to the last exhibit 20. So where you have a situation where you have a base DSU as a 1280, like for example in the orange outline, in this scenario, there would be no reason to allocate production outside of a spacing unit that's been defined by the NDIC.
Yeah, respectfully, TJ, that's not my question. Where here in Exhibit L20, does it show that Equinor does the same allocation as far as overlapping and underlying units as Continental? Where do I see that specific example in L20?
Oh, that's not on this exhibit.
Okay, thank you. I'll continue. Paragraph 8, the North Dakota Dominic v. Equinor, 2022 ND 211. The North Dakota Petroleum Council also filed a brief in support of Equinor. The Petroleum Council claims the readings advanced by the Dominics would create a, quote, fundamental shift, end quote, in how production is allocated in North Dakota, which would result in widespread litigation and delayed production on federal and Indian lands. Do you know, does Continental's position as far as allocation agree with the trade association that represents 98% of operators in North Dakota, or don't you know?
We don't allocate production based on acreage outside of the spacing unit.
Okay, and again, respectfully, that's not my question. My question was, do you know, is Continental's methodology that you've testified to today with respect to allocation between overlapping and underlying units, is that the same methodology that's supported by the Petroleum Council?
Only when there are BLM lands attributed by an overlapping comm agreement.
And I'm glad you brought that up. Let's look at the Petroleum Council's brief, again, filed as Exhibit A to, the Petroleum Council's brief, and Dominic filed as Exhibit A to the pre-hearing brief. I'm at page 7, heading C, and I'll quote, and this is the Petroleum Council's brief. Producers, the commission.
I'm going to object. If he wants to provide the witness a copy of that brief to review, I'm happy for him to do that.
Respectfully, Continental just submitted 20 pages of exhibits that I just got this morning, and if counsel can ask her witness about those 20 exhibits, he's testified as to the CA and treatment, and I'm going to quote and read a portion from that brief that talks about that and ask him whether that's consistent with his testimony.
If the witness would like the counsel's opinion in front of him after he asks him, he can have it if he needs it.
May I approach the witness?
Sure.
Read paragraph C for me. Let me jump to the mic, I apologize. Read paragraph C from the Petroleum Council's brief to the North Dakota Supreme Court, heading C on page 7, please.
This bold part right here.
The bold part.
Producers, the commission, and federal government allocate production from overlapping spacing units across the entirety of the affected base spacing units.
And that's units as in plural, correct?
That's what it says right there, yes.
Okay. Now let's go down in paragraph 7 and read that underlined sentence. What does that sentence say?
Next, they allocate production across base spacing units, either wholly or partly within the overlapping spacing unit.
Again, the Petroleum Council, base spacing units as in plural, correct?
It is in plural, yes.
Now, what is your understanding of what Andrew Sandifer, if you have an understanding, what they're claiming the base underlying spacing unit is?
Well, what they're claiming is the base spacing unit is sections 23 and 26 and 35 and 2 and sections 34 and 3. Yeah.
Correct, and that's paragraph 4 of Andrew Sanders' application. What are they claiming the overlapping spacing unit is? Do you know?
I believe that's the sections 34 and 3 and 35 and 2.
Yeah. It would be in paragraph 6 of the application, paragraph 7. The overlapping spacing unit consists of sections 34 and 35, Township 147 North, Range 96 West, and sections 2 and 3, Township 146 North, Range 96 West. Does that comport with your understanding of what the overlapping spacing unit is in this case?
Yes, that is the overlapping spacing unit.
And isn't it true that sections 35 and sections 2 are in both the overlapping spacing unit and the underlying spacing unit?
Sections 35 and 2 is the base spacing unit.
And 35 and 2 are also in the overlapping spacing unit that have the Carson Peak 4 and Whitman FIU 13 wells, are they not?
Yes, they are.
Thank you. If you don't know, or if you don't have an opinion, just tell me. When the North Dakota Supreme Court at paragraph 9 of its Dominic decision writes, quote, Continental Resources filed an amicus brief noting it is the largest oil and gas producer in North Dakota. Continental agrees with the method advanced by the Dominics, end quote, with respect to the allocation. Do you have any reason to disagree with that statement today?
I'm going to object to that on relevance, and also Mr. Botchell was not presented to speak as to the North Dakota Supreme Court cases.
He can answer it if he knows.
Okay.
Will you repeat your question?
Sure. I'll sum it up. The North Dakota Supreme Court states in their decision, Continental agrees with the method advanced with respect to the allocation between overlapping and underlying units, advanced by the Dominics. Is that still Continental's position? Is that statement correct?
I don't remember. I think that's right, but I don't know. Yeah.
Say it in mic, please.
Yeah, I don't know.
Okay. And I don't want to spend a lot of time on this, but I didn't get a resume or CV for you, so as far as your background and your experiences, do you have a degree in anything?
Yes, I have a degree in, I have an MBA from Oklahoma City University in finance and marketing.
Okay. Do you have an undergrad degree?
Yes, it's in finance as well.
Okay. Any education or training in matters related to being an engineer?
No.
Did you prepare a written report describing your conclusions and findings in this matter?
No, I didn't prepare a written report.
You had testified when your counsel asked you about would you say it's hundreds of thousands of mineral owners that Continental asserts would be impacted by a decision in this case? Did I hear your testimony correctly?
No, I think in this specific case is on Exhibit L18, it's 210 royalty owners. I think
Okay, and
Mr. Stewart would say.
right before we went to lunch, I thought I heard you testify that, and if I'm wrong and you didn't testify, just tell me and we'll move on. My understanding of your testimony was that outside of this particular instance in the application, that ruling for Andrew Sandifer here would impact thousands of mineral owners that Continental operates wells for. Did I hear that right, or did you not say that?
I don't believe I said that.
Okay. The L18, the 200 some mineral owners, let's pull that up. $210 under what Continental describes in L18 as an imaginary allocation. That's the number of combined working interest owners and royalty owners that would be impacted, what Continental asserts would be impacted by a decision here by the commission. Is that correct?
That's right.
Is it fair to say of all those 210, they're similarly situated and the same facts would apply as to how that allocation methodology would be treated as for those 210 owners that you've identified in L18?
Yes, all of these owners are going to be diluted and have to pay back revenue that's already been distributed.
Okay, so the same set of facts and the same law then would be operative to all 210 of those mineral owners? Or would there be any differences?
I'm going to object to this question as calling for speculation, vague, and you're not defining the terms here.
Yeah, and respectfully, again, I was provided this exhibit this morning. It's not my numbers on there. These are Continental Resources numbers where the witness has already testified 210 mineral owners would be impacted. My question, what I'm driving at, would all of them be impacted and diluted in the same way, or are they some sort of distinguishable where 50% of owners are impacted one way and 50% the other?
If he knows, he can answer.
There are different, so some owners own in sections 34 and 3, some owners own in 23 and 26, some owners own in 35 and 2, and some owners own in a combination of them. So it's a multiple variety of changes that would have to happen. But at a minimum, they're all going to be diluted and be reduced. The owners in 23 and 26 are going to have a gain.
So what this exhibit then shows is that all those mineral owners, as far as the dilution, they're all going to be impacted similarly by the dilution then?
I'm going to object to asked and answered.
I don't think he has. I think the witness can answer.
He can answer.
Yeah, these are all the owners that are currently being paid in the spacing unit. And what the Sandifer application is asking for is that be changed and be distributed to a different spacing unit.
And my question was the dilution would apply across the board and impact all those 210. Is that what you're telling me? I'm trying to understand, TJ, how the dilution would impact, because you're testifying to it, your counsel asked you to it, so you brought it before the commission. How would that dilution, would it apply, notwithstanding where it's located? So forget about where the interests are located, but the fact it's going to be diluted, as Continental says here in Exhibit L18, would that dilution be this, and I'm talking again, just the fact they would be diluted. This exhibit says all 210 would be diluted in the same manner if the commission rules for Andrew Sandifer. Is that what your testimony was?
I'm going to object to that question as vague. And also, it depends on how the applicant asks for the production to be reallocated, which they do not do in their application, so Continental cannot answer that question.
And respectfully, it's their exhibit. What I'm asking him is to help me understand, and he testified to the dilution. So the exhibit's been accepted into evidence. What I'm trying to understand when you're talking about dilution, what exactly is that dilution for the 210 owners?
It says.
If he knows the answer, he can answer.
Yeah, so it's either going to be by a third or by the percentages up here in the top, depending on how it's whatever, however they recommend it or whatever.
Okay, and just so I'm understanding, this exhibit, the 210, that says all 210 will be diluted according to Continental, is that correct?
That's correct.
All right. At any point prior to today, so before today, had you ever had occasion to review or read Mr. Stewart's reports at Exhibits 2 and 3?
Yes.
When did you read and review those?
I don't know the exact, Thursday?
Why did you review them?
They were pertinent to this case that we were coming to?
Yeah, they were, and when your testimony there, did you, and I'll move on, you didn't prepare any sort of documentation responsive to Mr. Stewart's report, did you?
No.
Okay. I don't have any more questions for you, thank you.
Mr. Broughton, any questions?
Yes, Your Honor, thank you. When Continental files an application to pool interests within an established spacing unit, does it ask to allocate royalties to anyone outside of that unit?
No.
And therefore, those royalties that are being pooled all exist within the same legal description that also describes the spacing unit?
That's correct.
And when you give notice of the hearings for establishing a spacing unit or forced pooling, is the legal description something that you put on the notice?
That's a publication notice, and it is included on the publication.
And so that legal description for a pooling or spacing hearing would cover all of the royalty owners to whom royalties might be allocated in that hearing, right?
That's correct.
And so they would have notice of those based on the legal descriptions?
That's correct.
You were asked, well, Mr. Swanson stated to you a number of times that Continental is the biggest producer in North Dakota. Do you agree with that?
We're a big producer. There's been quite a few acquisitions over the last couple of weeks that we may not be the largest producer at this time.
Would you say over the course of the last 10 years, Continental has generally been the largest producer in the Bakken?
Most definitely.
And so as a matter of how often things are allocated in a certain way, in the Bakken, things have been allocated most often the way Continental suggests we should do it.
That is correct.
You were asked a number of questions about the Petroleum Council's filings in the Dominic case. Are you aware of the filing from EOG Resources indicating that it agreed with the allocation methodology proposed by Continental in the Dominics?
Yes.
And are you aware that they said that they distributed millions of dollars of proceeds from property in that same manner?
Yes.
And are you aware they also said that they're representative of many operators in the state who allocate overlapping unit production according to the method endorsed by the Dominics and Continental?
Yes.
You were asked a number of questions about whether the applicants had paid their proportionate share of the drilling and operating expenses for some of the wells in which they're participating. And so my understanding is that the applicants participated in the wells in the, well, let me ask you, did the applicants participate in some of the wells we've discussed?
Yes, they did.
And are those the wells in the, well, tell me which wells generally the applicants participated in.
They participated in the Hawkinson wells, all the 1280 wells there. They participated in the 4 2560 wells between the Hawkinson and Whitman. And then they participated in all of the 2560 wells between the Morris and Carson Peak. And they participated in the section line wells between the Hawkinson and Morris unit.
And just to be clear for the record, when we say they're participating in those wells, are you saying that they are paying their proportionate share of the drilling expenses prior to the drilling occurring?
Yes, that's correct.
Do you know if they are a leased or an unleased mineral owner?
They are a working interest owner.
So they're unleased?
No, they're lessees. They're not mineral owners.
Okay, so they're not a lessor.
No, that's correct.
And so because they didn't pay their proportionate share of the drilling expenses, if they wanted to participate in the section line wells, their interest is subject to a 200% risk penalty for all drilling and operating expenses, right?
I'm going to object to the extent that misstates the law and the administrative code provisions that require an invitation to participate in an AFE in the well before a risk penalty be assessed.
I'm just asking him if he knows.
He can answer.
Can you state your question again?
If none of the drilling expenses were paid and no participation occurred for an unleased mineral interest, would Continental assess a risk penalty of 200% against that interest if it was a non-participating interest?
That is correct.
Are you aware of any, well, I'll leave it at that. No further questions.
Any questions from the staff?
TJ, I think I just have one. For the lease line wells in question here, who pays the royalty owners?
Continental does.
So Continental pays 100% of the royalty owners,
Yes.
not the producer or the purchaser, it's Continental itself?
We pay the royalty owners. We send out those checks.
Okay, thank you.
TJ, just two quick questions, I think. On L2,
Yes.
you have the Continental ownership and the applicant's, or interest in the applicant's interest in all the spacing units. You don't have the same values presented for the Hawkinson? Do you know what those are?
Yes, I do. The applicants own 10% working interest in the Hawkinson unit.
And Continental would have?
Continental owns a 45% working interest, and the balance would be 44%.
And then, one more, I think when you were discussing L15, you may have misspoke. Let me double check hold on, 1 second. Yeah, L15, I believe you mentioned that it was the, base spacing unit when you were testifying. When you look at that exhibit though, you're not referring to that as the base spacing unit?
No, this would be the overlapping spacing unit for the
Okay.
section line wells.
Thank you.
Ms. Kaiser, any redirect?
Just a couple follow-up questions. So on that same exhibit L15, this does show Were we looking at 15? Okay. It does show the 4 1280 base spacing units.
It does. They're the ones outlined.
Okay. And then one other follow-up question. On exhibit L18, Mr. Swanson tried to ask you if all 210 owners would be diluted. Are you able to discern for certainty from their application how they would propose to reallocate production?
No.
If the reallocation was done under the second diagram with the 50% share to 34 and 3, 25% to 35 and 2, and 25% to 23 and 26. Would sections 34 and 3 be diluted in that instance?
And I'm just gonna object. In Andrew Sandifer's application, they do state how they want the production allocated, and Mr. Stewart testified extensively here this morning as to that, what he called, I think, a two-step process. So to the extent these questions try to mischaracterize what Andrew Sandifer's position is, I'm gonna object.
You can answer.
Your question again, please.
If they were to be reallocated based on the second graphic that you have over the imaginary allocation, where 50% of the overlapping spacing unit is allocated to sections 34 and section 3, 25% to sections 35 and 2, and 25% to sections 23 and 26, will the owners in sections 34 and 33 necessarily be diluted?
So if the owners only own in sections 34 and 3, they would not actually be diluted in that scenario.
So it could be less than 210, depending on how the applicants intend for that production to be reallocated.
That is correct.
Also, Mr. Swanson asked multiple times if you read or heard in the North Dakota Supreme Court opinion in Dominic, he kept referring to base spacing units, plural. Is that significant to you at all?
In this case here, the base spacing units would be sections 34 and 3 and sections 35 and 2.
Okay. No further questions?
Anything further? Okay, you can call your next witness.
Mr. Bankston is going to call our next witness.
At Continental Resources, we call Mark Okerman.
Stay.
Oh, you want to switch?
I'll just, yeah.
Yeah, give me that. Nope. That's yours. Okay. Might not help me.
Mr. Okerman, please raise your right hand. You solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief.
Yes.
Please state your name.
Mark Ogerman,
By whom are you employed?
Continental Resources.
Okay, in what capacity?
I am the Director of Exploration and Subsurface Performance.
In that role with Continental Resources, what are generally your responsibilities?
I lead a team of geologists, geophysicists, petrophysicists, and reservoir engineers, specifically those who were developing the Williston Basin and the Anadarko Basin, to all the subsurface parameters and understandings of those two basins for exploration and development activities.
Okay. Have you previously testified before the NDIC?
No.
Okay. Would you please highlight for the commission your educational background and work experience?
You bet.
And I'll make this objection now, just to preserve and protect the record. Andrew Sandifer renews their objection to any testimony from this witness who is not properly disclosed pursuant to Rule 26 of the North Dakota Rules of Procedure. Additionally, I'll object to the commission considering anything in Exhibits G1 through G8 that I was just handed. This is literally the first time I've seen these exhibits. They were not previously provided before. I was just handed a copy, so to the extent the witness testifies in his capacity or purported capacity as an expert or testifies as to the exhibits, I would object and move to exclude those for the same reasons as stated in Andrew Sandifer's pending motion.
As long as we're making a record here, I will make the record that we offered to exchange exhibits with the applicants on Monday, and they refused. And we handed him the exhibits prior to the start of the hearing today.
Okay, and so the record is clear, and we can supplement it with those emails. On Friday, the email that I provided, Thursday, May 30th, emailing counsel for Continental was asking them to produce the documents and exhibits and come in conformance with the rules. At no point did Continental do that, and I disagree. Exhibit G1 I did not have this morning. I literally just got it.
The objections are noted, but you can continue.
Thank you. Okay, do you remember the question, or do you want me to repeat it?
I think I've got it.
Okay.
My education is Bachelor's of Science in Earth Sciences from the University of Texas Permian Basin in 2005. I earned my Master's of Science in Petroleum Geology from the University of Houston in 2008. I've worked in the oil and gas industry continuously with an operator for the last 16 years. Operators that I've worked with are High Mount Exploration and Production, Chesapeake Energy, American Energy Partners, and for the last 7 years with Continental Resources.
Okay. Do you have any professional certifications?
I do. I'm a certified petroleum geologist from the American Association of Petroleum Geologists.
And when did you obtain that certification?
Good question. 2000 and stretching my memory. 2000 and I don't know. I can't remember.
Okay, that's fine. You got it.
I've got it.
Okay. Currently, you're the Director of Exploration Subsurface Performance. In that role, please explain what you do regarding Continental Basin's Williston Basin assets.
You bet. So again, I lead a team of highly technical subsurface professionals, geologists, geophysicists, petrophysicists, reservoir engineers, and those teams are tasked with developing Continental's assets in North Dakota and the Anadarko Basin. Those are the two basins that I specifically shepherd, and the development activities and the exploration activities associated with those two assets.
Have you previously testified before any other states' oil and gas commissions?
In Oklahoma.
How many times?
Once.
And just generally speaking, what was that? What did that involve?
It was an operatorship dispute on a 1280 spacing unit in southern Oklahoma.
And were your qualifications to testify as an expert witness in that proceeding accepted by the OCC?
They were.
I would move to certify Mr. Okerman as an expert witness in the area of petroleum geology.
Same objection that he was not properly disclosed pursuant to Rule 26.
Objection noted, motion granted.
Mr. Okerman, are you sponsoring any exhibits today?
I am.
And what are the numbers of those exhibits you're sponsoring?
Those are G1 through G8.
And were all of those exhibits prepared by you or under your direct supervision?
Either by me or under my direct supervision, yes.
Okay. Let's turn to Exhibit G1, if you would. What does that exhibit show?
So I'll start by walking you all through this exhibit, this first map. Some of the things that we see on these maps will be consistent from page to page, so we'll talk through that real quick. The red outlines are the base 1280 spacing units as for the Hawkinson, the Morris, the Whitman, and the Carson Peak. The wells within those base spacing units, I've identified the parent wells, what I'm calling the EchoPad development wells as the dash lines, the infill development as the stippled lines, and the section line wells as the dash dot. This map particularly represents a petrophysical analysis of 4 representative wells within each of these 1280 spacing units. So the large red dots in the Hawkinson, the Morris, the Whitman, and the Carson Peak are the wells that were used in this petrophysical analysis and this representation. So as you can see, as you look at the call-out boxes in green from the Bakken to the Three Forks, when we look at original oil in place per 640, which is OOIP per 640, there's a fair amount of variation in oil in place per 640 as you move from each petrophysical data point throughout each of the base 1280 spacing units. So what that indicates to me is variations in underlying rock properties, such as porosity and fluid saturation, in addition to thickness.
Okay. Is there any variation that you see in the OOIP throughout those 4 base spacing units?
There is, if you look at the OOIP per 640 numbers, you can see that the Hawkinson is a 29.4, Morris is a 23, Whitman is a 33.3, and Carson Peak is a 30.0.
Okay. Let's turn to Exhibit G2, please. Will you explain what that exhibit represents and what information it contains?
You bet. So Exhibit G2 is an additional representation section of the petrophysical variation throughout those 4 wells on the previous page. So the 4 wells that we're looking at here correspond to the red dots that were on the map initially. And what you can see is, again, in the oil in place per 640, there is variation throughout each of these base spacing units. The other thing here to note is the green circles on the well logs indicate the development strategy for each of these units, with the anomaly being the Hawkinson unit where Three Forks 3 was developed.
And along the right side of each well log, you've called out what, the formation identifiers?
Correct.
Okay. And what formations you identify there?
So here we're looking at the Bakken, Three Forks 1, Three Forks 2, Three Forks 3, Three Forks 4.
Okay. Please turn to Exhibit G3 and explain what is depicted on that exhibit.
Exhibit G3 is a Bakken time structure map based off of the 3D data that's available over the Hawkinson, Morris, Whitman, and Carson Peak units. What this map represents is the structural complexity within this area. Warm colors on the map indicate structural relief, whereas the cooler colors indicate lower structural relief, so high versus low. And what we can see is throughout the Hawkinson and the Whitman, we have different structural relief than we do in the Carson Peak and the Morris. Specifically called out on the yellow oval is an area where we have the highest amount of interpreted structural relief in the Whitman unit.
Okay. And that, what does that indicate to you as a petroleum geologist?
That indicates to me that there is something anomalous happening in the structure of that particular unit relative to the offset units.
Okay. Please turn to Exhibit G4 and explain what's depicted on that exhibit.
So G4 is another look at the structure of the Bakken. This time we're taking it from the geophysical space in time where the geophysicist works and putting it in subsea TVD, incorporating the well logs that have been, or the wells that have been drilled in the area. This is just a check to make sure that the seismic data corresponds with the wells that have been drilled and everything lines up. Although it's not colored, you can see by the contours that the Whitman structural anomaly is still present relative to the Carson Peak Morris where it's not.
Okay. And again, on this exhibit, you've called out the 4 base spacing units that make up the Oakdale field?
Correct.
Okay, please turn to Exhibit G5 and explain to the commission what that exhibit depicts.
G5 is a geophysical attribute called basement similarity. And the intent of this map is to provide an interpretation as to why there is a structural anomaly within the Whitman and trending towards the Hawkinson and not in the Carson Peak and the Morris. So this particular geophysical attribute is trying to look at the similarity or differences from seismic trace to seismic trace. And when we see an area in the Whitman where we have deep black colors on this particular color bar, that indicates to our geophysicist and to me that there's something different that's happening there. Typically, that's a fault that we would want to investigate more. So this is a tool that we can use to understand how and why some of the anomalies in the Whitman are popping up.
And on this exhibit, is that called out in the yellow hatched circle?
Correct.
That area?
Yes.
Okay. You've also got a yellow X on this
Yes.
exhibit. What does that indicate, or why is it there?
So that yellow X is there because I wanted to illustrate the Whitman 334, which is a well that was drilled in 2011 that Continental was drilling ahead, anticipated it to be, normal reservoir conditions, but ran into an unexpected anomalous reservoir character there from about 13,430 feet to 13,681 feet, where we saw increased pressure and anomalous reservoir character within the Three Forks.
Okay. And that yellow X, is that where that well was located?
That's the approximate location of where we TD'd the initial well and had to flow back that well for a period of time.
Okay, please turn to Exhibit G6. Indicate what that exhibit depicts.
So G6 is two seismic sections, seismic section C to C prime and seismic section B to B prime. So we'll start with seismic section C to C prime, which is on the bottom of the page. That's a section that runs from south C to north C prime through the Whitman and the Hawkinson unit. The intent of this section is to show the geophysical tie to the Pelton 110 synthetic log, and the intent there is to show how well behaved the seismic data is relative to well control and well data, and the ability for our geophysicists to interpret this data very, very cleanly. Seismic section B to B prime is a section from west to east that runs through the Whitman and Carson Peak unit, and we've situated that line so that it would run through roughly where we TD'd the initial Whitman 334H well that we had to stop short. The important thing about this section is we have interpreted a fault that is in the basement section. So if you look on the left-hand side of that seismic section, I've called out where the Bakken horizon is, the Prairie Evaporite, the Red River, and the basement. So in the basement section, we've interpreted a fault that runs through the basement, which sets up the structural anomaly in the Whitman unit.
Okay, please turn to Exhibit G7 and explain what that exhibit shows.
Exhibit G7 is a geophysical attribute called maximum curvature. This particular attribute is run on the Bakken surface. It's a well-known attribute that we use throughout the industry, and the intent of it is to understand with flexures and with curvature in the subsurface how much potential natural fracturing could be associated with that curvature, with that structural ridge.
Okay, and again, the yellow hatched elliptical circle and the yellow X show up on this exhibit?
Correct. So the yellow oval indicates an area where we see increased maximum curvature, which leads us to interpret that as having the potential for enhanced natural fractures.
Does does any information on this exhibit substantiate or confirm to you potential fracture anomaly?
Yes, sir.
What is
Again,
that?
Where the yellow X is where the Whitman 334H well was initially TD'd. where we saw anomalous reservoir conditions, enhanced pressure, and had to TD that well early due to safety concerns.
Okay, please turn to Exhibit G8 and explain what that exhibit shows.
G8 is an additional look at fracture potential in the Bakken. This attribute is a little bit different. This is called curvedness. So this looks at all of the potential curvature variations and gives us a comprehensive understanding of the total curvedness of that particular feature. Again, calling out there in the yellow oval an area of high total surface curvature, and that we interpret that as having the potential for enhanced natural fracturing.
And does that conclude your testimony regarding exhibits G1 through G8?
It does.
You were here this morning when Mr. Stewart, the applicant's expert, testified, correct?
Yes.
And have you previously seen a copy of his expert report?
I have.
Okay. If you would look at page 5 of his report, the very bottom of that page.
And I'm gonna make an objection. This is the exact sort of prejudice why Andrew Sandifer brought its motion to exclude. Continental has had the benefit since last week of having Mr. Stewart's report. And all these documents at L1 through L20 or 21, G1 through G8 and everything else, the first time Andrew Sandifer was provided them was this morning, putting us at a substantial disadvantage when preparing to cross-examine any witnesses offered by Continental. So I'll object to any questions that Mr. Bankston has for the witness with respect to Mr. Stewart's exhibit.
Objection noted.
Thank you. Mr. Okerman, at the bottom of page 5, he refers in there to order number 14496. Do you see that?
I do.
Okay, turn to the next page, page 6. At the top of that page, he's quoted language from that NDIC order. And paragraph 1 of the order lists 8 factors that the commission shall consider when establishing spacing units. Do you see that?
I do.
Okay. Please read the first factor listed by the commission in that order.
Geologic conditions such as uniform thickness, porosity, and permeability, absence of faults, and structural anomalies.
Do you agree that geologic conditions are an important factor to be considered when establishing drilling and spacing units?
I do.
How important are they in that process?
In my opinion, understanding the geologic conditions provides context for equitable share of production based on subsurface consistency or subsurface variation.
And why is that important?
The consistency or lack thereof throughout multiple spacing units could potentially affect equitable share of production.
And does it generally tell you what size units to create?
Yes.
Okay. In the context of establishing drilling and spacing units in the Oakdale pool, did Continental take geologic conditions into account?
Yes.
And please describe what geologic conditions exist and how they impacted Continental's decisions when establishing the drilling and spacing units in the Oakdale field.
The structural anomaly that runs through the Hawkinson and the Whitman units were taken into consideration, as well as the lack of structural anomalies in the Morris and Carson Peak unit.
Okay. And all those have been previously testified by you two in your exhibits, correct?
Correct.
Okay. In your opinion, should the commission also take those geological conditions into account if it were to ever consider amending or revising spacing units in the Oakdale pool?
Yes.
Okay. What are those conditions and how should they be considered by the commission?
Again, the structural anomaly, the strong structural anomaly in the Whitman would be the main condition to take into consideration, as well as the Hawkinson, and then the Morris and the Carson Peak, fairly continuous or uninterrupted structural anomalies there.
Okay. Based on the information contained in your exhibits G1 through G8 and your testimony today, have you formed an opinion whether or not it would be just and equitable to allocate production from the Whitman base spacing unit to any of the other 3 base spacing units in the Oakdale field?
Yes.
What is your opinion?
That it would not be equitable to use the Whitman base spacing unit to allocate production to other base spacing units
And why not?
due to the structural or the subsurface anomalies that we see within the Whitman unit.
And the impact on production?
Correct.
I would move to admit Continental Exhibits G1 through G8.
Same objection.
Objection noted, the exhibits are admitted.
Thank you. No further questions.
Mr. Swanson.
Thank you. Mr. Okerman, you mind if I call you Mark?
Go for it.
All right, fair enough. A few quick questions. The structural anomalies you've mentioned several times during your testimony. Fair to say that in North Dakota, and forgive me, I have no background in geology, so I'm relying on you. The structural anomalies you talked about with regard to the Oakdale field, are those present elsewhere in North Dakota?
Occasionally.
Occasionally. What do you mean by that? I'm trying to get an idea of, is this something that's these structural anomalies, in your experience as a geologist for Continental, how often do you guys run into these structural anomalies like you testified to with the Oakdale field?
Throughout the Bakken, throughout the Williston Basin, I would say less than 5%.
Okay. So are you familiar at all with the commission's position as stated in Dominic?
I'm not.
Okay, you're not. Do you know or are you aware of any carve-outs or exceptions with respect to the allocation between underlying base spacing units and overlapping base spacing units that require structural anomalies to be taken into account each time?
I'm not.
Okay. If those structural anomalies would have to be taken into account, then, and again, help me understand this, I'm not trying to trick you. In cases, maybe that, did you say 5% of the time there are structural anomalies, give or take?
Less than.
Less than
5 or
5?
less.
Okay, so in those situations where there are structural anomalies, should the allocation between base units and overlapping spacing units, as far as section line wells, differ anytime an operator says there are structural anomalies here?
Trying to understand your question.
Sure, what I'm asking is that every time that there's a structural anomaly and we're looking at the allocation between an overlapping and underlying unit, should structural anomalies, anytime an operator says, look, and I'll give you an example, if you don't know, you don't know. If an operator says, we would have allocated it this way like Dominic, and allocated a share like Mr. Stewart testified to during his testimony, which you were present for. If an operator says, look, we typically do that, but here there are structural anomalies, so we should be allowed to allocate it differently. Is that what you believe?
I don't believe so.
When you take a look at Mr. Stewart's report, it's at page, I believe, 9 of 40, figure 5.
Not for-
9 of 40 on the bottom. Page 9 of 40.
You bet.
Yeah. I believe it's stamped Andrus 10 on the bottom as well. You got that in front of you?
Yes, sir.
Okay. Sections, to your knowledge, does Andrus Sandifer have an interest in sections 23 and 26?
I think this is a bit outside of my technical scope.
Okay. All right, and that's fair. I'll ask it this way. Would this be, what's going on in Exhibit L number 2, case number 26144? This was an exhibit prepared by Continental. Does this indicate that for this particular well that Continental filed in case number 26144, that this would be a 2560 stand-up spacing unit?
Objection, speculation, no foundation. This is an exhibit this witness prepared.
Yeah, and I'm asking if he knows. If he doesn't know, he
Yeah.
can say he doesn't know.
He can answer.
I don't know, outside of my technical scope.
Okay. How long have you been working in oil and gas? Do
16 years.
you know what a spacing unit is?
I do.
And you're telling me in the commission today that you don't know whether that means that the well that's subject of Continental's own Exhibit L2, you don't know whether that's for a 2,560-acre unit?
Without more time to review this particular item, I can't answer that.
Do you know, and again, if you don't know, you don't know, so just tell me you don't know. With respect to the Industrial Commission's orders in order number 14604, order 14262, and order 28556, which were the orders creating the stand-up 2560 that we're talking about today, where Andrew Sandifer's interested in. Do you know if those orders been terminated?
I don't know.
Did you prepare a report in this case, Mark?
No.
Those are all the questions I have. Thank you.
Mr. Broughton?
With respect to the anomaly in the Whitman unit, did you see an increase or increased production in those wells as a result of that?
Yes.
And in the last 4 months, well, let me ask first, are you somewhat familiar with the production from the 2 section line wells under issue?
I'm somewhat familiar. Our reservoir engineering witness would be much more familiar.
Okay. No further questions.
Any questions from the staff?
Mark, with, I guess with respect to the information that you're presenting on G3, G5, 6, all the seismic interpretation that you have in your exhibits here, when did Continental become aware, when did they take that seismic? When did they become aware of this, other than when they encountered it in the drilling of the Whitman well, when did they have this information?
So the seismic was acquired in 2013, I believe. However, the structural ridge in the Hawkinson and the Whitman in industry was known since the early 70s, late 70s, where 2D seismic was used to understand this particular anomaly. Not necessarily to the detail that the 3D gives us, but there was a known structural anomaly in the area.
Looking at your G6, specifically your C to C prime, you identify the Peloton 110 as the synthetic seismic log.
Correct.
Can you identify where that well's located when, looking at G5 or anything like that?
It is just off the map, unfortunately. I've got the section number down below it. Really hard to see. It's small font, but the line C to C prime is there in orange, and it's just off the map north of where the C is.
Do you know what the section township range on that well is?
We can provide that if you'd like.
I think with respect to the comment that was just made as far as the small exhibits, I was already going to ask that a number of the exhibits be provided digitally so that they can be read. The description boxes and the equations in them are next to impossible to read on
That's-
this scale, so.
We're happy to do that.
I want to return to that line of questions that I started. I'm not quite sure how I'm going to ask something here, but with respect to the ridge, as you identified, you said it was understood since pre-70s or in the 70s roughly that there was a structure there?
That's my understanding.
Okay. When Continental would have been in front of us requesting the 2560s in the first place, looking at your L6, which would put it around the 2010 timeframe. So you were, at that time, Continental was aware there was a structural feature through there.
We were aware there was some structure there, but not quite understand the magnitude or the degree of the structural anomaly.
Okay? So when attempting to comply with the requirements of that order number 14496 and the testimony in the, or not the testimony, but the portions that you were asked questions about in the other experts' report, the geologic conditions, uniform thickness, porosity, permeability, absence of structural faults and anomalies, do you have any idea how Continental would have responded to those questions or provided that information at those hearings?
I don't.
If you were asked those questions today, specifically after seeing the information that you've presented on 3 through 8 here, what would your opinion be of the geology between the Hawkinson and the Whitman units? Would you consider them of uniform thickness, porosity, permeability, and absence of fault and structural anomalies?
I would consider them fairly uniform thickness, porosity, saturation, but not consistent from structural or other reservoir anomalies.
Okay, thank you.
Yes, sir.
Mark, on your exhibit G1, you have some wells in a boulder dash labeled EcoPad development, and then all the other dotted lines are labeled as infill development. Why isn't the pad in the northeast of section 26 considered an EcoPad?
So for my labeling on EcoPad, that was relative to the 4 wells drilled in the Hawkinson, Whitman, and the Morris Carson Peak at that time. So that was just me using the terminology when those wells were spud of how we would have identified those as EcoPad wells.
And if I understood your testimony correctly, if I heard it correctly, towards the end of your direct testimony, you said that, if I mischaracterize it, go ahead and correct me. You said that based on the structural anomaly in the Whitman spacing unit, the production from those wells should not be reallocated to any other spacing unit. Is that roughly what you said?
Yes.
So is, in any part of this proceeding, is anybody advocating for a reallocation of production from the Whitman spacing unit to any other spacing unit?
I believe so.
Okay, thank you.
Any redirect, Mr. Bankston?
No redirect.
Anything further?
Just one question, if I may.
Sure.
And Mark, forgive me, I'm not a geologist, but I do know that back around 2010 or 2012, when the initial Whitman wells were drilled, sections 23, 26, 35, and 2 were a single 2560 spacing unit, were they not, when the initial Whitman wells were drilled?
Say the sections again, please.
Yeah, 23, excuse me, was it the Morris or Carson Peak? I might have my wells confused, but my understanding is initially, and it goes to one of the questions that was asked by the commission, sections 23, 26, 35, and 2 were initially back around 2010 or 2012 spaced as a 2560 unit before, at some point, 35 and 2 were made a separate 1280, and the Whitman FIU wells were drilled, correct?
I don't believe so. The parent wells in sections 23 and 26 and 35 and 2 were initially spaced as 1280s, to my understanding.
Okay. when the, and I don't mean to combine the two, maybe it was when 22, 27, 34, and 3 were drilled, and I think it was the initial Whitman drills, wells in that 2560, when those initial Whitman wells were drilled, they were drilled and they're still allocated as if that's a 2560 unit, are they not?
He lost me. I don't know what 2560 you're referring to.
The 2560 of Hawkinson and Whitman, sections 22, 27, 34, and 3. Initially, the Whitman wells that were drilled in there were in a 20, that unit was a 2560 acre unit, correct?
To my understanding, the parent well development was on 1280 spacing.
Okay. And the ridge, just so I don't really understand it, so help me out a little. The geology that you were asked about that ridge being present in the 1970s, but then Continental still doing the 2560 acre spacing around 2010 or 2012. Was the ridge not a factor in 2010, 2012 when that 2560 spacing was done?
So 2010, 2012 would have been pre-3D seismic acquisition. So our understanding of that structural feature would have been more or less consistent with previous understanding. There was accuracy there, but not preciseness. So the 3D data gave us a little bit more preciseness on what that structural anomaly looks like.
So how did Continental know in the 70s the ridge was there?
Again, this is my understanding based on reading publication and wells that were drilled, deep wells that were drilled in the area.
Sure. I don't have any other questions. Thank you.
Okay, Mr. Banks, you can call your next witness.
Continental calls Sarah Hale.
Thank you.
Ms. Hale, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do. Afternoon, Sarah. Can you please state your full name for the record?
My name is Sarah Hale.
And by whom are you employed?
I'm employed by Continental Resources.
In what capacity?
I am the manager of the Williston Basin Resource Development Team.
And how long have you worked at Continental?
I've worked at Continental since 2012.
Can you highlight for the commission and Mr. Swanson your educational background and work experience?
Yes, so I graduated from the University of Oklahoma in 2011 with a degree in petroleum engineering. From there, I went on to work for Schlumberger for approximately a year. After leaving Schlumberger in 2012, I went to work for Continental Resources. I've been employed by Continental Resources in a number of different capacities. I've been a project management engineer. I've been an engineer in resource development for quite some time, and I've been a supervisor and now currently a manager within that role as well. I've worked in both the Anadarko and the Bakken throughout that time frame.
Can you describe your current role? What's your current title, actually?
My current title is manager of the Williston Basin Resource Development Team.
And describe for me your responsibilities in that role.
Yeah, so largely our group is in charge of the Williston Basin development plans. So we are looking at density, spacing decisions. We're looking at any decisions that we might have influencing on the stimulation to pair with that. We're working on budgetary decisions, larger scale planning, the timing of development as well. So we're a mix of reservoir and planning.
And does that analysis require a good understanding of the geological and petrophysical characteristics of the reservoir rock and fluid,
Yes, it does.
as well as performance of the wells drilled?
Yes.
Okay. I'm not going to quiz you as an attorney, but are you familiar with the term correlative rights?
I am. My understanding of correlative rights is that all owners within like a common source of supply are entitled to their just and fair portion of hydrocarbons that are produced within that pool.
And that's really a legal term, and you're not here to offer a legal opinion.
Yes, that's correct.
But is it your understanding that in order to obtain a spacing order from the commission, that order must protect the correlative rights of affected owners?
Yes, it needs to protect the correlative rights as well as being balanced with making sure that things are not wasteful, and there's no drilling of unnecessary wells.
And is it also your understanding that a pooling order requires the operator to operate within a spacing unit in a manner to protect correlative rights of all impacted owners within the spacing unit?
Yes, I'd agree to that.
So does your well planning and development analysis, as manager of the Williston Basin Reservoir team, consider the impact of proposed wells will have on correlative rights, as we've just discussed?
Well, we do lay out the development plan, and we do try and lay that out with every intention of recovering the resource that's in place in the least wasteful way, protecting the correlative rights of the interest owners within those units, as well as making sure that that's done in an economic manner. Upon deciding what that layout looks like, we then go to the commission with recommended spacing that fits that. So I would say yes.
Okay. Based on Ms. Hale's qualification and experience, I move to certify her as an expert witness in the area of reservoir development and oil and gas production.
And I'm going to protect the record and object. I think this is probably the most egregious violation of Rule 26 that we have here. Rule 26, as far as experts, 26 B4(1), a party may through interrogatories require any other party to identify each person whom the other party expects to call as an expert witness at trial to state the subject matter of which the expert is expected to testify, the substance of the facts and opinions to which the expert is expected to testify, and a summary of the grounds for each opinion. In the discovery responses, which asked those very questions to Continental, which were filed with this commission as part of Andrew Sandiford's two motions earlier this week, Exhibit A to the motion to exclude and Exhibit 3 to the motion in responding to limit scope, there is literally no substance of the facts and opinions to which the expert is expected to testify. That's entirely lacking in their disclosures. And there is no summary of the grounds for each of Ms. Hale's in that disclosure either, that it prejudices, not only does it violate Rule 26, it prejudices Andrew Sandifer because, again, they have not had the opportunity to review those and are about to hear them for the first time. So based on that, we will object to her qualification as an expert and any offering of her as a witness and consideration of her testimony.
Objection is noted. Motion is granted.
Thank you. Ms. Hale, are you familiar with the Oakdale field and what the applicants are seeking from the commission today?
I am.
You were here earlier for Mr. Dwayne Stewart's expert testimony, correct?
I was.
And then were you able to review Mr. Stewart's expert report provided by the applicants late last week?
I was.
From that testimony and his report, are there any specific points or opinions that you disagree with?
Yes, the main piece that I disagree with is Mr. Stewart's conclusion that he can attribute interference between a well within the unit to a single additional well that was installed at the same time as other wells. We'll go through production within my exhibits shortly, but I'd like to point out an exhibit that he's provided, if you'd let me take you through his.
Now, can you tell us what page?
Yes, so this is going to be E12. The page says Andros 00132. It will also be E14, and that's 00134, and E16 00136. Now, Mr. Stewart made a comment that he is largely ignoring the number 5 and number 6 well that are approximately closer to the Carson Peak number 2 well that he continually refers to as a base spacing well. And in that, he says he ignores those wells because he does not see the same GOR profile as he does as in the Carson Peak number 4 well. Well, looking at his own exhibits, I would conclude that that is not true. Looking at the Carson Peak number 4 well, the GOR increases the same time on E12 as the GOR increases on the Carson Peak number 5 well on E14. And then going to E16, this is one of the highest GORs. This is also the well closest to the Carson Peak number 2 that Andrew Sandifer has brought, the applicants have brought to the attention of the party here. So this is the highest GOR. So, you know, for it to be said that there is no discerning GOR differences within these wells, I do not think was a truthful statement.
And why is that important to the analysis of what the applicants have alleged that the section line wells are essentially draining or harming the correlative rights of the applicants?
I think it's important because they say conclusively that the section line well is the well interfering with the number 2 well that they're referring to as a parent per se. So you can't look at those wells collectively and say which one is pulling from any other shift in reserves.
Okay. Are there any other opinions that you disagreed with in Mr. Stewart's testimony or his report?
I disagree with pulling, or I shouldn't say pulling, I disagree with spacing the Whitman well beyond the extent of which that section line well is influencing. I say that due to, you've just heard Mr. Okerman's testimony on the geological anomaly within the Whitman unit. It does have anomalous production as well, which we'll talk through also. Further extending the Whitman owners to a unit that's not even neighboring this unit, I think is egregious.
Okay. Let's switch to your exhibits.
Okay.
Are you sponsoring any exhibits today?
I am. I'm sponsoring Exhibit E1 through E11.
And were those exhibits prepared by you or under your supervision?
Yes, they were.
Do you know about when you started preparing these exhibits?
They started to look more like this about 10 days ago, maybe 2 weeks ago.
Okay. So having read the application and Mr. Stewart's report, how do you analyze their position, or how would you analyze what they're asking for today at this hearing?
And I'll object that she's being asked to analyze what Mr. Stewart or Andrew Sandifer is asking for.
I'm sorry, that was a bad question. I'll withdraw it. How would you evaluate whether or not a section line well is causing harm to correlative rights in adjacent wells?
I'm sorry, say that again.
That's another bad question. How would you analyze the impact of a section line well on wells close in proximity to that section line well?
Looking at individual impact is difficult without making some operational adjustments, doing shut-in pressure testing, and evaluating well-to-well interference. And that's a very specific operation, not something that's typically done just in general shut-ins. In situations like this, where none of that activity has occurred, it is difficult to discern where any production is necessarily allocated to.
Okay, let's walk through your exhibits.
Okay.
So on Exhibit E1, is it your understanding, you've heard over and over here today the definition of base spacing unit. Is it your understanding that the base spacing units in the Oakdale field are the Hawkinson stand-up 1280, the Whitman stand-up 1280, the Morris stand-up 1280, and the Carson Peak stand-up 1280?
Yes, that's my understanding. Those were the first established horizontal wells within these units,
Okay.
all on a 1280 basis for each one.
Okay. And what does the production from those wells tell you?
I'm going to start more at the top and
go
then
for it.
walk down. So we'll be going through the spacing and development timing through these. It's kind of a time series flip through how these wells are installed. So the original base spacing units are 4 separately spaced 1280 units, one in the Morris, the Carson Peak, the Hawkinson, and the Whitman. All of these wells come online between the 2008 and 2010 timeframe. From the production results of that, I'll take you to the graphic at the bottom. Sorry, one second. Before I do that, in the block diagram, this diagram is not particularly adjusted for any specific ratio. So in a few slides, and a few exhibit slides later, I'll show you a more one-to-one ratio look at this. So this is for illustrative purposes only on the block diagram. But we've also included the year that they come on and my understanding of whether or not the applicants have ownership within those wells.
And that's indicated by the
yes
the
and
Y
no.
and the N. Okay.
Yes.
Thank you.
So the graphic on the bottom is cumulative oil production on a one-year basis from these wells. Now, there's not a dramatic performance difference in these wells by the one-year mark. However, with the exception of the Hawkinson unit coming on in 2010, that has a larger stem, so we wouldn't expect that to perform exactly the same as the others. So at this moment, the 1280s individually, there's no reason why we don't see that we could move forward with pursuing 2560s on our next development.
Okay. Move on to Exhibit E2.
Okay. So this is moving on to 2011. The stand-up 2560 units are established. So this is two separate stand-up 2560 units, and this will be 4 wells per 2560 developed. I've also listed some general orders that I feel like are pertaining to this. Now, this is not an exhaustive list of orders, so there are other orders that are happening amongst this time or as we roll through. But NDIC orders 14261 and 15126 are associated with these. At this time frame, we put 2 wells in the Hawkinson unit, 2 wells in the Whitman unit, and that is 1 stand-up 2560 combined. We put 2 wells in the Morris unit and 2 wells in the Carson Peak unit as 1 2560 combined. Now, here's where things start to show different colors. So I'm going to take you down to the same cumulative oil production graphs down at the bottom. This is, again, a one-year time frame look. The Carson Peak and Morris stand-up 2560 don't really have production that's dramatically different from one another, but when you look at the Hawkinson-Whitman production, you can really see a standout difference here between the Whitman number 3 and the other Hawkinson wells. So the Whitman number 3 is one of the top Bakken producers on a 12-month cumulative oil basis, and this well was developed in 2011, so that's saying something relative to the stem size that were associated with it. We also have the Hawkinson or the Whitman number 3 in this as well, and the Whitman number 3 is a well that we have to stop drilling because it starts flowing on us as we're drilling it. We have to kill the well, get out of there. We don't complete it, and we leave it flowing by itself naturally until we come back and re-enter this well in 2017. So this well is less than 2,000 feet and is producing naturally by itself. So this tells us there's something unique in this unit. Now, the Hawkinson ERC joint project has not happened yet, so we don't have the hyper-specific details on exactly where that's limited to, exactly what's influencing that, but we do know that there is something structurally going on within the Whitman unit at this time.
You heard Mr. Okerman's testimony earlier. Does the production from the 2 Whitman wells confirm essentially what he testified to on the geology?
I think it does. So you don't see it originally on the Whitman parent. The Whitman parent is on the western side of that unit. If you look at Mr. Okerman's exhibits, you'll see that that structure sits more on the eastern side. And so these wells falling close to where that structure is shown in his exhibits makes sense that that would have an influence on the production here.
And you probably wouldn't know that until you actually drilled the wells, correct?
That's correct.
What was behind the decision to drill the Hawkinson and Whitman 2560s and the Morris and Carson Peak on 2560s?
So generally, we drill 2560s for a number of reasons. When you can consolidate wells on individual pads, you can extend the amount of lateral that you get. So there's less reserves left untouched, per se, and when you do that. You also have a little bit of flexibility to where you can work with complicated surface. Dunn County is a place where there's a lot of topography on the surface. Anywhere that you can make adjustments for that and keep your pads consolidated is a pro. So,
perfect. Moving on to Exhibit E3.
okay. So Exhibit E3 is 2013 through 2015. This is the Hawkinson 1280 acre density, and that is completed. This is a joint project with the EERC for, there to really be an evaluation around density and proper development. NDIC Order 2972 is a decent reference in terms of what's going on here from commission rulings. So at this point, 12 wells are installed in this 2013 to 2015 timeframe. These are installed on a 1280 basis, so we are no longer pursuing the 2560 in the Hawkinson and the Whitman unit. I've reposted the Whitman-Hawkinson graphic down below. So this is a combination of two things. We want to pursue the EERC project in the Hawkinson unit. This is going to involve drilling Three Forks 3, drilling at a tighter density. We don't have intentions of mirroring that in a anomalous unit with geological structure like the Whitman. So these have been split up, and the intentions to go forward here are 1280 and 1280.
And given the discrepancy in production, why is that significant to go back to developing these on 1280s versus a 2560?
Well, as pointed out, I believe that Mr. Bingston referenced it in Mr. Stewart's exhibits, but the stand-up 2560s should be geologically similar and absent of structure according to that ruling from the commission. So that would be in violation of that.
Okay.
So.
Okay, let's move on to Exhibit E4.
Okay.
So we're getting a little busy here. Can you, because I'm not an engineer,
Yeah.
explain your color coding and its significance for me?
Absolutely. Let me just mark down my own color coding before I start blabbering too much. Okay, so it is getting a little busy here. The marcation of the colors, and I'm now also introducing shapes to make it more complicated, I apologize, but this is to show the sets that these wells are coming on in similar conditions. So as we go through here, we started with the green wells, which were those 1280s on the base 1280 spacing units. Then we put in the yellow wells, which are the stand-up 2560 acre spacing wells. Then the 15 well project of the Hawkinson was completed. Those are blue now. There's only 12 wells that go in the blue, but it's listed in the legend box as the 15 well because collectively that unit is now complete with the exception of the section line well. And then now we're moving on to the installation of the orange wells. So these orange wells are infill wells on the stand-up 2560 basis in the Morris and Carson Peak unit, as well as wells that are installed between the Hawkinson and Morris unit in a section line 2560, which is more of a square shape, and wells that are installed in the Whitman unit and the Whitman Carson Peak unit as a section line 2560 also. So the main point of the top graphic here is to take away that nothing happened in a vacuum. The applicants talk continuously about the impact on the yellow wells that they're referring to as the base spacing unit, and they are pointing at the section line wells, saying that these wells are the impacting wells on the yellow stand-up 2560 wells within the Morris and Carson Peak unit. There are closer wells. There are wells that are showing signs of being bound to the 2 and 3 wells as well. So I don't feel like you can conclusively say that section line has any influence or any undue influence on specifically the Carson Peak 2 and 3 and the Morris 2 and 3.
So there could be communication and interference. There's just no way to determine which well it's coming from.
Yeah, at a density like this, you'd expect your wells to be bound, right? If this has been a long-going density, we started this in 2008, it's now 2024. If we weren't seeing signs of all of these being bound at this point, we would think that we probably left reserves behind and there was something else to go grab.
Understood.
At the bottom of this graphic, I try and cut out a little bit of noise and highlight just the section line 2560s. Now the box is not a representation of the 2560 over the block diagram, but I just want to highlight the timeline of these in a little more specificity. So in 2019, the applicants participate in the 2 section line 2560 wells developed in conjunction with the offsetting stand-up 2560 Carson Peak and Morris West half. So that's all the orange wells that are being developed between that Hawkinson and Morris block. on the northern end. Now, at the same time as that, the single well is being put in place in the Whitman Carson Peak unit in the section line. Now, they do not have interest in that, but the applicants don't file or don't bring a complaint up with Continental Resources until 2022, even though that section line 2560 was developed at the same time under the same conditions with the stand-up 2560 to the south.
Okay, I want to ask you a couple questions about this particular graphic. To dumb it down for myself as a lawyer and not an engineer, I'm going to refer to the Hawkinson Morris northern section line wells as the A unit for
Okay.
purposes of this discussion, and then the Whitman and Carson Peak section line wells unit as the B.
Yeah.
The B section line wells. Okay. Is it your understanding that the applicants own in the A section line wells to the north?
That is correct.
And we know by virtue of their application today that they do not own in the B section line wells to the south.
Correct.
By their logic, or by Mr. Stewart's testimony and analysis this morning, couldn't the Carson Peak owners make the same argument as the applicants to participate in the Hawkinson Morris A section line wells?
And I'm going to object to the extent she's asking for the witness to speculate on what logic or intent that Andrew Sandifer may or may not have had.
She can answer.
Yes, so under the same technical merits, which a section line 2560 well that is neighboring a stand-up 2560 that they're arguing is undue influencing their wells, that same thing applies to the northern half. You have a 1280 neighboring a stand-up 2560 unit with a section line 2560 in between them. But there's been no complaint about the unit to the north, only the unit to the south.
And they would be diluted, their interest could potentially be diluted if the owners in the Carson Peak were to make that argument and be
Yes,
successful
I'm
in that
not an
application.
expert on how that would all divide up, but
Sure.
they could be diluted.
Okay. But to your knowledge, they have not asked to be diluted in that unit.
To my knowledge, that has not been.
Okay, thank you. Moving on to Exhibit E5.
Yeah, moving on to E5, 2021, this is largely uneventful in terms of conversation in this series, but because we're talking through what's happening unit by unit, the Morris Carson Peak stand-up 2560 unit is finished out with the 2021 development. These are the purple wells on the western half.
Okay. Exhibit E6.
E6 is the finale to all of this happening here. So the infill development on the 1280 unit spacing, 8 Whitman wells are installed, as long in addition, a single section line within the 2560 is installed as well. So there's one additional overlapping section line 2560 well, and then the infill is completed, and that is the last of the development through this footprint.
Is there anything looking at this full development profile, looking at the production, that gives you any indication that Continental did not space or pool these units in the Oakdale field correctly?
No, I think they are spaced correctly.
Is there anything you would do different with this information, having the benefit of Monday morning quarterbacking? Is there anything you do different today with this information?
Well, clearly the Whitman 2560 wells are outperformers relative to the Hawkinson. If we knew what that production would look like in advance, I don't think we would have pulled those together.
Okay. Moving on to Exhibit E7.
E7 has the same graphic up top. It has a time scale down at the bottom. It's just a legend as all this was installed. All we're illustrating on the graphic on the bottom is a timeline here. So this timeline has all of the series being mentioned down at the bottom, but on the top, we list the orders. So these are temporary and permanent spacing orders that are issued by the NDIC. Continental has made no less than 20 appearances in front of the commission in order to see this through. So this development that's been happening, first wells come online in 2008, last wells come online in 2022. 20 times we're standing here without objection.
And you heard Mr. Botchlet testify earlier that no issue was raised by the applicants with Continental or the NDIC until sometime in 2022, correct?
That's correct.
And that would be towards the end of your timeline.
That would be towards the end of our timeline and about 3 years after the first section line well in the south half is put online.
Okay, thank you. Describe for me the purpose of Exhibit E8.
The purpose of Exhibit E8 is really just to bring a little bit more proportionality to all the block diagrams that have been shown today. So you see that the reason we can't show the block diagrams in this look is that it takes up a lot of real estate on the horizontal length of the page, but not a lot of real estate on the vertical aspect. So this is a 1-to-1 ratio. We've zoomed in on the area of interest where the Carson Peak number 2 and the Carson Peak number 4, as well as the Whitman number 13, are all included so that you can get a better 1-to-1 ratio understanding of exactly the distance between those wells in particular.
And did Mr. Stewart provide that clarification in his report?
Mr. Stewart, I would have to go back and see exactly what he said, but his, similar to mine, just distorted in the opposite direction, was not a 1-to-1 ratio.
And that could be misleading if you're looking just at that diagram in a vacuum.
Yeah, it could be. When it's not 1-to-1, it can be misleading.
Okay. Let's move to E9, please.
Okay.
Actually, I'm gonna make this a little easier. Let's talk through E9 and through E9, E10, and E11, kind of in a narrative form.
Okay. So Continental's position is that you cannot point at any one single well installed at the same time and say that that is the causation of any type of interference to a parent well that has been online since 2011 with a significant depletion footprint. So we want to walk through this in a series of clusters of wells. So what we do is we've put a block around here. So first, this first slide on E9, we are looking at the nearest offsets to the section line wells. So the graphics below, the gross monthly oil production and the gross cumulative production, are both graphics that are only those 3 wells. The markers on the graphics below are marking the installation of the surrounding wells as we go through this. So starting with the gross monthly oil production, looking at this, the 2011 well is put online, so that's the Carson Peak number 2, that is producing without any offsets until the development of all of the orange wells above in 2019. There's a significant bump in production, showing us that there were plenty of reserves to grab with additional wells being installed next to that unit. Going on until 2021, the offsetting wells are established in those units. You see no distinguishable change in production from there. And then lastly, the Whitman installations happen in 2022. That is the red line across the production, and there's no distinguishable shift in production as there either. So from our look, keeping it at just a simple production look, no forecast, which can be a bit subjective, we do not see a negative impact to the nearest offsets to the section line wells within the Carson Peak unit. Going on to expanding this out so that we aren't gerrymandering anything, we take this out to a full mile from the full half mile from the section line. So same story, the red box is encompassing the wells that are in the graphics below, and the timeline moves largely the same. You have the 2 wells in the beginning. Those are producing until 2019 when they're offset by the orange wells, the increased density in the stand-up 2560, as well as the section line well being installed. A large increase in production as those installations occur. Moving over, the wells are installed in 2021 on the west half of the unit. Again, the production largely seems unbothered. And then going into 2022, you can see the artifact of the shut-in briefly, but then besides that, again, the production looks unshifted by the installation of the section line wells. And so no stone is unturned. We take that out to the full Carson Peak south half. So this does not include the Morris unit to the northern half, but this is just the full south half, all wells that are labeled Carson Peak, with the exception of the 1280 base parent well, because that is not on the 2560 spacing. And same story. Wells are online. That's the 2 yellow wells to start with. An enormous bump in production as the orange wells are installed. The 2021 wells add additional reserves into this mix because they are now looped into the graphic. And then the wells that are put online in the Whitman unit, as well as that section line well that happens in 2022, does not make a distinguishable difference in the collective Carson Peak 2560.
Would you characterize this unit as a successful unit?
I would. Collectively to date, the unit has cumed about 7 million barrels of oil on a gross basis.
We've gone through your exhibits. I have a couple more questions. The first, you said you started working on these exhibits a couple weeks ago. Is there anything that you changed in these exhibits based on your review of Mr. Stewart's report?
So I did review Mr. Stewart's report, and there was actually one addition, and this was in reference to both Mr. Stewart's work and my own work. So that would be the block diagram. Both of us are not using a 1-to-1 ratio in our block diagram, so it's only appropriate to show a block diagram that encapsulates what this unit really looks like when it's ratioed equally.
And that's the only change in your exhibits?
That's correct.
So having reviewed the full unit development and production, do you have any opinions as it relates to the applicant's request to be allocated production from the Whitman Carson Peak section line wells?
I think the reasoning in which they asked to be allocated production is not conclusive. So I do not think we should progress.
Okay.
I also think that the opportunities to step forward and object to these.
And I'm going to object to the extent she's testifying as to latches. She wasn't disclosed for that, and that's beyond her scope to testify as to why or why not Andrew Sandiford did or did not object.
I'm gonna let her continue.
I think the time to object to the layout of these units is when the units are proposed and heard at the NDIC. The NDIC makes these rulings, and they're setting these rulings forward with correlative rights in mind, with the drilling of unnecessary wells in mind, and with the prevention of waste in mind. All we're doing is following through with what's been ruled upon.
As the manager of the Williston Reservoir Development Group, earlier Mr. Stewart mentioned that sometimes it could take up to 5 years for him to properly evaluate the interference of wells. How would it affect your drilling program or your ability to establish a drilling program if you were constantly in danger of having your spacing and poolings challenged after having well results?
If we were retroactively shifting after every 5 years of a well being put online, we could potentially just end up sitting here constantly and having conversations about wells collectively all the time. We make those decisions to the best of our knowledge that we have at that time frame. They're not done maliciously. They're done with the facts that we have at the time frame.
So they're not done arbitrarily?
No.
Or to the benefit of Continental?
No, they're not.
Even if that were the case, in this specific case, did you identify any technical evidence to support their request for allocation from the section line wells?
I do not have any conclusive evidence. I will not disagree that the Carson Peak 4 is showing signs of bounding. I do not think bounding is a bad thing. I think wells should show signs of bounding in a full development layout. Those wells are also brought online at the same time as the others, so that well should not be extensively reaching out into that unit. It is bound so that it is staying within that section line corridor.
Thank you. I move to admit exhibits E1 through E11.
And Andrew Sandiford has the same objections to including, for the same reasons already noted, for including this witnesses, exhibits, or testimony.
Objections are noted, the exhibits are admitted. 2 issues. You wanted to supplement the record with emails, Mr. Swanson.
Correct.
How long do you need to get those into the record?
Friday.
Friday? What day is that, Jim? 2 days from now?
Yes.
7th? And you, Mr. Suggs had requested digital copies of certain exhibits. How long do you need the record open to supplement?
I can send those in the next 20 minutes if you'll give me a good
We'll
email
leave the
address.
record open till
Okay.
Friday. The record will remain open till June 7th. Okay, Mr. Swanson.
Yeah, it's my turn to ask some questions of
Yes.
this witness. Thank you. And I'll try to keep it brief and not go over old ground. Mind if I call you Sarah?
Yeah, please.
Right. Do you know, did Continental provide actual notice to Andrus Sandifer about its drilling of the either Whitman FIU 13 well or the Carson Peak 4 section line wells?
I would not be part of any notification, so I cannot answer that.
Okay. When did the Whitman 13 FIU start producing?
That would have been in 2022, but I don't know the exact month. I don't have the exact month written on my exhibits.
And I'll represent the scout ticket data for the commission shows it was July 2022. Do you know when the Carson Peak 4 section line well started producing?
That would have been in 2019. I believe it was June, but I also don't have that month in front of me.
Good memory, you are right. Scout ticket data shows June 2019. Earlier, I heard testimony that Andrus Sandifer sent a letter to Continental objecting to the fact they didn't get allocations from these wells in 2022. Did you hear that?
I did.
Were you aware of that?
I am aware of the letter. That's correct.
So they send a letter in 2022 complaining about it. The very same year, the Whitman starts producing.
Mm-hmm.
Is that a yes?
Yes.
Right. You had the benefit of reviewing Mr. Stewart's report last week and coming up with your exhibits, is that correct?
I did.
Okay, and you only made a single change to your report after that?
I only made one change.
Okay. Were you, no, never mind.
And I'd like to clarify, we were still in working order within these, so if you look at a timestamp, you will still see shifts, but that is the only change I made due to the information within Mr. Stewart's report.
You mentioned that, and I want to make sure I understand correctly, 20 appearances, I don't think, but correct me if I'm wrong, are you saying you were in front of the commission 20 times, or that on 20 occasions Continental has been before the commission with respect to the Oakdale field?
It will not be me. Within 20 times, Continental has been in front of the commission for spacing, so that's exclusive of any pooling. That's going to be the temporary and permanent spacing orders.
So let's go to page 9 of 40 in Mr. Stewart's report. It's Exhibit 5.
Is exhibit, okay. Hold on, it takes a minute to, which page now? I'm sorry.
It's stamped Andrus 10, it's page 9 of 40.
A 9 of 40, okay,
Yep.
sorry. When you said exhibit 5, I thought you meant the.
Oh, sorry, I
tab.
might have said that. If I did, I misspoke. I meant figure 5 in Mr. Stewart's report.
Okay,
This is from an exhibit Continental filed in case number 26144. There was an order issued, order 28556, which is referenced in Andrew Sandifer's applications. Would this have been one of the times, case number 26144, that Continental was in front of the commission with respect to the Oakdale field?
that's not one of the orders I have listed, but that does not mean it's not one of the time Continental was in front of them. If it is a Continental unit, it should be a time that Continental was in front.
Yeah, and I'll read the case caption for case number 26144. In the matter of a hearing called on a motion of the commission to consider the appropriate spacing for future wells in the 2560 acre spacing unit consisting of sections 23, 26, 35, and 2 Oakdale, Bakken Pool, Dunn County, North Dakota, and other relief as appropriate. Do you have any reason to disagree with that?
No, I don't.
So if I scroll down and I'll do you understand that Andrew Sandifer has interest in sections 23 and 26?
Yes, I do.
And do you understand that per order number 28556, those interests in 23 and 26 are spaced in a unit with sections 35 and 2?
I do.
do you know did Continental drill any wells in that spacing unit consisting of 23, 26, 35, and 2?
We did. We have drilled multiple stand-up 2560 wells as well as two 1280 wells. The 1280 wells were the first in the succession of that. There's a 1280 in the Morris, a 1280 in the Carson Peak, and then a series of stand-up 2560 wells.
I'll represent to you. Paragraph 8 of that order mentions 4 horizontal wells drilled and completing in that 2560, including the Continental 226H, Continental's 226H Morris well, the 326H Morris well, the 235H Carson Peak well, and the 335H Carson Peak well. Do you know, those wells would all be then in that 2560 with sections 23, 26, 35, and 2, is that correct?
They are the yellow wells in my block diagram.
Okay. So when I look at the commission's brief, in Dominic, paragraph 25, quote, "The commission also believes the lease line horizontal," well, let me back up. The Carson Peak 4 and Whitman FIU 13 wells at issue here today, they're in a overlapping spacing unit that consists of the same sections 35 and sections 2 we just talked about, correct?
I'm sorry, can you repeat that?
Sure. The Carson Peak 4
Okay.
and Whitman FIU 13 section line wells?
Yep.
Okay, you're familiar with those?
Yes.
They're in an overlapping spacing unit that consists of the same sections 35 and section 2 that are subject of multiple commission orders, including order number 28556.
They do encompass 35 and 2 in the section line 2560.
So is it your testimony then that there may be some situations and circumstances where, in a circumstance where, just like here, 35 and 2 were spaced in the same unit as 23 and 26, if there's a section line well in 35 and 2, there are circumstances where it's your position that the owners in 23 and 26 shouldn't get any allocation from the section line well?
I'm going to object to that question. He's restating her testimony for her, and I don't believe that she testified to that.
I'm not restating, I'm asking if that's her testimony.
She can answer.
Please repeat the question.
Sure. So is it your position then that there may be situations, because we've established that sections 23 and 26, where Andrus Sandifer have an interest are in the same spacing unit as sections 35 and 2, pursuant to order number 28556 from the commission. Do you agree with that?
I do agree with that.
Okay. Do you agree that sections 35 and 2 are also spaced in an overlapping spacing unit where the 2 section line wells at issue are located?
I agree with that.
So is your position then that there are situations where, despite that spacing in the shared sections 35 and 2, where there may be circumstances where Continental should not have to allocate an interest from section line wells like the CP4 and Whitman FIU 13 to owners in sections like 23 and 26?
Yes, I think that's one of those situations. As I had mentioned at the beginning of this, when Ms. Kaiser asked me if there's any reasons that I do not agree with Mr. Stewart's conclusions, one of those reasons is that I feel like the sections 34 and 3 are a geologically anomalous unit. Further extending that to 23 and 26, which does not even share a single section overlap or adjacent to this, would be a stretch, and you'd be extending people with a geologically different rock into different quality. So I do not think that that should continue to extend further. It makes sense to have 35-2, 34, and 3 because the wells are section line wells between those 4 units, 4 sections.
So when you say a stretch, when the commission states in its brief in Dominic in paragraph 25, quote, "The commission also believes the lease line horizontal well may cause positive or negative impacts to all wells and base spacing units shared by all interest owners within the spacing units. Therefore, the commission believes all pooled owners within the base spacing unit should be compensated, not just the interest owners in the sections located within the overlapping lease line spacing units," end quote. So that's a stretch then for all wells and spacing units.
Now, you said all wells within the base spacing unit. I think we disagree on what the base spacing unit is.
Sure. You would disagree that in this situation, that despite the fact Andrews Sandifer shares a spacing unit that's subject of case number 26144 and the order issued by the commission, which is a Continental Case Order 28556, you disagree that despite Andrews Sandifer having an interest in a spacing unit with 35 and 2, that they should receive an allocation with the Carson Peak 4 and Whitman FIU 13.
If their ownership's in 23 and 26, I do not agree that they should receive an allocation.
Would you agree, or do you have no knowledge that order number 28556 is still in effect?
I would assume that to my understanding, none of the orders within the Oakdale Block and Pool have been dissolved.
Same would be true then for order number 14604 and 14262?
I believe so, but I'm not an expert on the state of the orders. But to my understanding and what I've reviewed, none of the orders, they've just been appended with additional zones.
Did you prepare a report in this matter?
I did.
Where is that report?
Oh, I'm sorry. I prepared exhibits, not a report. No.
Okay, thank you. I don't have any other questions for you, Sarah. Thank you.
Okay, thank you.
Mr. Broughton?
Thank you, Your Honor. I just have a couple quick questions
Yeah.
for clarification. You made a couple references to wells becoming bound. Are you referring to the interactions generally described by Darcy's Law?
Yes, so I think a great illustration is actually the illustration that Mr. Stewart had in his exhibits. But ultimately, you will hit a no-flow boundary between your wells, and that is from bounding of neighboring wells. So to me, that when I'm saying bounding, I'm saying that you have two wells competing for the same reserves, and you're going to be stunted to where you're being offset to, if that's a easier way to put it.
Because the pressures reach a state of equilibrium and prevent fluids and hydrocarbons from migrating at that point?
Yes, you are going to be in a different pressure flow regime.
No further questions.
Any questions from the staff?
So Sarah, when operators drill lease line wells, do those lease line wells recover hydrocarbons from the base space units?
They do recover hydrocarbons from the base spacing units. They're on the lease line, so they'll be tapping into reserves on both sides and sections on both sides.
And in particular, in this case, the Carson Peak and the Whitman lease line wells, do they have any communication or interference with any of the base spacing unit wells?
They do not. From our definition of base spacing unit, the 1280 wells are not interfered on by these.
How about on the 2560 wells?
We do not see direct interference. We do see a bounding effect, but we cannot discern any shift in production that's noticeable on what they're calling the base 2560 parent wells that is attributable to the section line wells.
So in Mr. Stewart's testimony, he spent quite a bit of time on interference. Was there interference between some of the wells?
I think that there's GOR that's escalating between the wells. Now, that can be an artifact of depletion. That depletion could be coming from either the Whitman unit, it could be coming from the existing Carson Peak wells. So those wells all come on with a higher GOR than the others, but they do recover an economic amount of reserves. I would say that you could say that that is a sign of them being bound, but it could also just be a sign of being drilled in a lower depleted environment.
So the difference in the production declines that he showed, those are not due to interference between wells?
I'm sorry, say that again?
The differences in the production declines he presented,
Yes, I do think that that is due to interference. I do not think that you can say that that is from the section line wells.
understood, but could the section line well have been part of that interference?
It could be.
And again, I don't know if I am mishearing Continental, but it seemed to me I heard again in your testimony that the Whitman stand-up 1280, the production from that 1280 should not be reallocated to any other spacing unit?
My testimony is that knowing what we know today, that the Whitman 2560 would probably have not happened, the original 2560. So that is the yellow wells on my block diagram. Now, that does not mean that we should not drill section line wells between the Whitman and Carson Peak. If there are reserves that are not being accessed by existing wells, additional wells should go in order to protect correlative rights and prevent waste.
Okay, thank you.
Thank you.
Any redirect?
Can we have 5 minutes break? A 5-minute
I'm
break?
sorry, I
Oh,
asked
sorry.
one question.
Lynn's got a question.
Sarah, a couple questions ago, you were asked about Darcy's Law. Is Darcy's Law applicable in an unconventional resource or reservoir like the Middle Bakken or the Three Forks?
I think it's a lot more complicated when you are in an unconventional reservoir. The permeability itself is generated from your completion, so understanding the flow radius and the exact mechanisms of boundaries, whether that's reaching the extent of where your completion is or whether that's interference between wells, gets much more complicated when you are in an unconventional reservoir.
So your answer is it's complicated?
Yes.
Thank you.
Why don't we take a 10-minute break then, right now?
Okay, great. Thank you.
Okay, we are back on the record. Attorney Kaiser, we were talking redirect.
Thank you. I have just a couple more questions. Ms. Hale, I am not an engineer. And so for clarification, there's been discussion throughout the day, both from you and Mr. Stewart, about well communication, well interference, terms like that. Does communication interference equal drainage?
No, not necessarily. So communication interference could be just seeing a boundary from each of the wells. It doesn't necessarily mean that a well is stealing from another well. Now, he does note a shift down in reserves of the Carson Peak number 2. I do not think you can distinguish which well is now accessing those reserves from the information that we have today.
Okay. So it's more the idea of communication interference is more pressure movement versus necessarily hydrocarbon movement.
It can be hydrocarbon movement, but that's more of a drainage issue. So
Okay. Okay, so communication interference is not synonymous with harming someone's correlative rights.
I'd agree with that.
Okay. And then lastly, you got a question about the Morris Carson Peak the Whitman Carson Peak section line wells, and if they were draining from the base spacing units.
If they're draining from the base spacing unit,
Yes, the section line wells. That would only be the base spacing units. So it would only be, so the Whitman FIU and the Carson 4 would only be draining reserves from the Whitman 1280 and the Carson Peak 1280.
that's correct.
No further questions.
Anything further?
No, Your Honor.
Anything further from Continental?
No, sir?
Nothing further.
Your Honor, sorry, I meant with that witness, one thing I just wanted to mention real quick, just because not everyone is my client, there might be public, I just wanted to
Okay,
say.
and let me apologize. I didn't ask you if you wanted to present any witnesses.
Yeah, and I would, so no, I'm not gonna present any
Okay.
witnesses, but there may be folks in the audience that aren't my clients, just so everyone's aware. I don't
Okay.
know.
Anyone with any comment? Okay. That concludes our hearing for case number 30604, and that concludes our hearings for the day.
Thank you.
Huh?
Is there,
Okay, we actually back on the record, and Continental, you wanted to bring up an issue.
Yes, we'd like to reserve our right to submit additional evidence to the extent the applicants are allowed to seek relief outside of that that's listed in their application as it stands today. Their expert report did go outside the scope of their application, and to the extent that that's allowed, that any kind of relief is allowed in that manner, we would like the opportunity to submit our own evidence to that.
Okay. How long do you need to keep the record open?
Well, it depends on, it really depends on the NDIC's ruling on the motion to limit the scope of their application.
it would, and, oh, sorry,
Go ahead.
yeah, it seemed to me that to the extent those issues have been briefed and there are pending motions, if the commission is inclined to either grant or deny, whether it's Andrus Sandifer's pending motions or Continental's, that would be a matter for appeal. I mean, we've had the evidentiary hearing. There was a whole host of exhibits we objected to that were provided today. If the commission is so inclined to keep the record open, I think this thing's been fully briefed, I think all the information is there. I don't know if the commission feels it needs anything, but to the extent if Continental is going to start filing, my concern is now we're engaging in a never-ending cycle of replies and sur-replies, and our witness filing something or wanting to reserve the right to file something to address Ms. Hale's testimony. So when does it end? So I don't know if the thing to do is just make a 21, 30-day period to file anything else, but my concern is we're just going to have endless motion practice at that point.
Yeah, I'm inclined to keep the record open, but not inclined to wait till the order comes out to allow you an opportunity to supplement the record after the order has come out. We're going to take those motions into consideration as part of our issuing of the order. And so if you want to submit anything in the next two weeks, we can accept that as part of your motion and consider it when we consider your motion.
Okay.
Okay.
Continental's good with that.
Okay.
2 weeks from today?
2 weeks from today. We'll keep the record open until June 19th. We can, yeah. Commission would also request that the parties submit proposed orders.
As far as the timing,
How long do you need?
The record's open for 2 weeks. 2 weeks after that. So 30 days.
30 days? Let me go off the record for a quick minute.
I don't know, what do you-
30 days works. Let me,
Can I make a selfish request that we go to the 8th instead of the 5th because it's the day after the 4th?
the 8th, is the 8th of July, is that the 30-day mark, basically?
Technically
Well,
the 5th
the
would
5th
be,
is-
but
Then we'll keep the record open until July 8th for proposed orders. Okay, if there's nothing else, then that concludes our hearing for case number 30604. That concludes our hearings for the day.